163A of the MB Act, he is entitled to get compensation. The claimant claimed that he was earning rupees 6,000 per month by doing class 2 contractor, but as a result of accident, he cannot do any work. The claimant nowhere submitted his return showing his income. Therefore, the claim of the claimant that he was earning 6,000 per month cannot be accepted. Lordship, may I just pause here? If it is 6,000, Lordship, as the claimant, then the claim petition under section 163A itself was not maintainable. Because as per the schedule, it has to be 3,300 per month, 40,000 per year. However, a man having good health can easily earn rupees 3,000 per month by doing any work. The claimant in her claim petition, or no, it should be, I think his, stated that at the time of accident, he was 40 years old. In his evidence, he stated the same fact. The document exhibited by the claimant before this court shows that at the time of accident, the claimant was 40 years old. Exhibit 3 clearly shows that the claimant was suffering from 45% disability. Therefore, considering the age of the claimant, the appropriate multiplier would be 16. As noted herein above, the claimant earned rupees 100 per day. For 45% disability, his loss of monthly earning capacity comes to rupees 1,350 on monthly income of rupees 3,000, and the annual earning capacity comes to rupees 1,350 into 12 is equal to 16,200. As mentioned herein above, before, the age of the claimant at the time of accident was 40 years. Thus, the appropriate multiplier, as noted here in above, 16 is applicable in this case. For permanent disability, compensation comes to rupees 16,000.
No, whether these are stipulated in section 163.
What, Lordship?
Is it stipulated in the section
What, Lordship? That 6,000.
163?
Yes, Lordship. The schedule is there, Lordship. As per the schedule, it has to be 40,000, Lordship. If an application, if Lordship will find the second schedule. Because in the new book, which Lordship won't find it because now the schedule has been removed and 163A has changed. Lordship will get it in the old book only. 163A, Lordship, the schedule is there. Huh? Oh. In the old book, I think page number 170. Tomorrow, 170. Move to 170. Purana Khan Divo Dada. Lordship can take mine also.
No, I got my old book. Okay.
Lordship got it. So then I'll continue with paragraph 10. As noted herein above, the claimant earned rupees 100 per day. For 45% disability, his loss of monthly earning capacity comes to 1,350 on monthly income of 3,000, and the annual earning capacity comes to rupees 1350 into 12 is equal to 16,200. As mentioned here in before, the age of the claimant at the time of accident was 40 years. Thus, the appropriate multiplier as noted herein above 16 is applicable in this case. For permanent disability, compensation comes to rupees 16,200 into 16 is equal to 2,59,200. So this amount we are first challenging this amount logic because the doctor did not deduce any evidence. Only the claimant himself produced the disability certificate based on which this amount is granted. The claimant in his evidence categorically admitted that all his medical expenditure are included in Exhibit 4, that is hospital bill. Therefore, the claimant is entitled to rupees 1,89,787, which is mentioned in Exhibit 4. The claimant also entitled to amount to the tune of rupees 8,500.
So this amount is not disputed. Medical expenses.
Not disputed, but then lordship, if he is a driver, he is driving a vehicle himself, his claim case itself is not covered by 163A. But lordship, herein something special happened in this case because at the time of stay, the court granted a stay, but directed us to deposit rupees 233,788, that is 50%, and the claimant was allowed to withdraw the amount, and he has withdrawn the amount. So, lordship, that fact remains. Can we recover it from him? I don't think that may be possible now. But the thing is, they are not entitled. The case itself, they are not entitled. I'll show Lordship Jumma Saha and our High Court judgments also, or Supreme Court judgment also, that if the person is driving a vehicle, borrowing it from the owner of the vehicle, then he steps into the shoes of the owner of the vehicle, because the owner cannot file a claim petition under the MP Act.
No, but at the relevant time, owner was also in the vehicle.
True. But he borrowed it from the owner. He was driving it in the capacity. That is what is stepping into the shoes of the owner of the vehicle. But that thing is there, Lordship. The claimant also entitled to amount of rupees a month shown in exhibit. Therefore, the claimant is entitled to rupees 189,788 plus 8,570, 198,377 for medical expenses. The claimant is also entitled to rupees 10,000 for physical pain and suffering, special diet, convenience. Thus, the total amount of compensation the claimant is entitled to rupees 2,59,200 plus 10 plus 198,377, 467,577. So that was the compensation which was granted. And out of that, we have paid. So, Lordship, actually, that is my case. That totally disability amount will totally go. Rajkumar, Ajay Kumar, Lordship, I'm giving Rajkumar, Ajay Kumar's judgment, Lordship, wherein the apex court. First, let me give.
No, not necessary, madam. I'm aware of the same.
Okay. And Lordship, for the thing Ningamma, Sunita Rathi, all the judgment should I give that if he steps into the
No,
shoes of
I think for that, yes, you can,
yes,
can furnish that.
yes, Lordship. I'll give all the. I have too many, but I think I'll give 2 or 3 only, Lordship. Otherwise, should I give all? I'll give the relevant Supreme Court. Number. I've given only one from our High Court and four from Apex Court on that point. First of all, Lordship will take up Ningamma. Paragraph 13, Lordship.
Yes.
In the light of aforesaid submission, the question that falls for our consideration is whether the legal representative of a person who was driving a motor vehicle after borrowing it from the real owner meets with an accident without involving any other vehicle would be entitled to compensation.
Which one you are reading first?
Ningamma, Lordship.
Okay. Paragraph number?
13, Lordship.
Yes.
I'll read again, Lordship. In the light of aforesaid submission, the question that falls for our consideration is whether the legal representative of a person who was driving a motor vehicle after borrowing it from the real owner meets with an accident without involving any other vehicle would be entitled to compensation under Section 163A of MBA or under any other provisions of law, and also whether the insurer who issued the insurance policy would be bound to indemnify the deceased or his legal representative. Before dwelling further, it would be useful to discuss the relevant paras of Section 163A and 166 of MB Act applicable in the present case. So the sections are discussed after that, Lordship. Then, Lordship will come to paragraph 18.
Yes.
In the case of Oriental Insurance versus Rajni Devi and others, that Rajni Devi also I have given, Lordship, wherein one of us, namely Honorable Justice S.B. Sinha, is a party, it has been categorically held that in a case where third party is involved, the liability of insurance company would be unlimited. It is also held in the said decision that where, however, compensation is claimed for death of owner or another passenger in the vehicle, the contract of insurance would being governed by the contract for contract, the claim of the claimant against the insurance company would depend upon the terms thereof. It was held in the said decision that that Section 163A of MVA cannot be said to have an application in respect of an accident wherein the owner of the motor vehicle himself is involved. The decision further held that the question is no longer res integra. The liability under Section 163A of MBA is on the owner of the vehicle. So a person cannot be both a claimant as also a recipient with respect to claim. Therefore, the heirs of the deceased could not have maintained a claim in terms of Section 163A of MBA. In our considered opinion, the ratio of the aforesaid decision is clearly applicable to the facts of the present case. In the present case, the deceased was not the owner of the motorbike in question. He borrowed the said motorbike from its real owner. The deceased cannot be held to be employee of the owner of the motorbike, although he was authorized to drive the said vehicle by its owner, and therefore he would step into the shoes of the owner of the motorbike. So, Lordship, that is the law. And thereafter, Sadanand Mukhi is also discussed in this. I have also given Sadanand Mukhi's case, Lordship. Sadanand Mukhi, the son was driving. The Honorable Apex Court held that there will not be any liability of the insurance company.
Next.
Next, Lordship, I'll give Rajkumar Ajay Kumar. For the, Lordship said that I do not need to give for the doctor not examined. Rajkumar Ajay Kumar. So that is my, if anything comes up, I'll give a reply, Lordship. So my humble submission is that the appeal may be allowed.
But you have already paid the amount.
Half of
the amount.
That is the tragedy, Lordship. Many courts, Lordship, without looking into the maybe the grounds of appeal, they so I cannot help in that.
Lordship, here in this case, my learned friend has referred to the page number 12 with regard to the issues. And in page number 12, the issues were discussed with regard to that particular issue because they did not lead any evidence. And there was no counter evidence with regard to the, because medical certificate, he is not pressing for that medical certificate. Now, the issue is that whether this 163 is applicable or not. Because initially the application was filed under 166, and subsequently during this proceeding, then it was converted to 163A. Now, the point is that, Lordship, this 3,000 rupees was taken into account as a person of good health is uh, in a position to earn that much of amount. So accordingly, that amount was taken into account, and pursuant to that calculation, Lordship, this compensation, the awarded amount has been fixed. Now, this what my learned friend is referring to, that with regard to the maintainability, because that was never been discussed, and that issue was never, because the maintainability in the written statement also, they did not raise that particular issue before the learned tribunal. So that issue was never been framed before the concerned tribunal to discuss with regard to that. So at this stage, because the law points is there, but even then, Lordship, this issue has never been discussed with regard to the fact that whether this is maintainable or not. Now, since this the accident has occurred, and there is a description with regard to the fact that some this, if you, Lordship, kindly see this page number 12, in this particular paragraph with regard to the whether the alleged accident occurred due to the use of the vehicle in question. Now, it has been mentioned the reason for that accident, because some other person came in front of the vehicle, and because to save that particular vehicle, it has to this vehicle collapsed, and accordingly it has to a tree or something like that.
So, 1 minute. Madam, this issue of maintainability was not raised before the tribunal.
Lordship, that the court itself has to look, because the court changed the section from 166 to 163A. Court changed the,
No, this is because of the
because Lordship,
income.
no, not because of the income. If it is filed under 166, then his own negligent driving. If a third person is involved in a rash and negligence, then it is okay. But Lordship, here he was himself driving. For his own rash and negligence, he cannot claim compensation. But Lordship, Dhanraj again says, Jumma Saha, I have given that judgment also, Lordship. For his own rash and negligence, one cannot file 163A also.
Lordship, kindly see page number 12, the story that has been narrated by the claimant. In the claim petition, it has been contended by the claimant that on 19/4/2007, he was driving Maruti car bearing registration number such and such.
12 of the
12, this memo,
judgment.
Lordship. This is the judgment, Lordship.
Okay.
After the framing of issue, the decisions and the reasons thereof.
Yes.
In the claim petition, it has been contended by the claimant that on 19/4/2007, he was driving Maruti car bearing registration number such and such from Vishwanath Charity, Guwahati. The owner of the vehicle, Niranjan Shaikya, also accompanied with him. When they reached the gate of such and such on the National Highway 37 under KTPS, suddenly an old woman and a minor girl come in front of the vehicle to save them, which turned the vehicle as a result of the vehicle dashed against a standing tanker. As a result, the accident, he got grievous injuries on different parts of the body. The vehicle was also partly damaged. In his evidence, he categorically stated the same fact, which he has described in his claim petition. Now, the fact is that, Lordship, is rash and negligent driving, because what has been narrated here, that aspect of the matter, the concerned claimant, because this is an injury case, Lordship, he was cross-examined by the insurance company counsel, Lordship, and that aspect has been specifically mentioned by the tribunal, that this aspect of the matter with regard to the accident occurred, the reason that was there for the occurrence of the accident, there was no rebuttal evidence with regard to that, because the rash and negligent on the part of the concerned vehicle which the claimant was driving, there is no such evidence from the side of the, because they did not lead any evidence with regard to that. So that aspect, the rash and negligent driving, cannot be mentioned or cannot be agitated at this stage, because there is no specific evidence to counter that contention or to establish that contention. So the learned tribunal, taking into account that there is no evidence on the part of the insurance company, and there was no rebuttal evidence or the evidence that was led by the claimant, that cannot be discredited in any manner. So in that view of the matter, Lordship, the 163A, the learned friend has referred to certain judgments, but the rash and negligent driving is very much essential to take note of this judgment, because the rash and negligent driver, the insurance company is to prove. They have not been able to prove that aspect, and whatever the reason for accident, that has also been established by a reducing evidence. So in that view of the matter, Lordship, this tribunal was justified in awarding the compensation by calculating 3,000 as the minimum amount, and accordingly the 45% was taken into account, the disability part, because The insurance company, there was no effort on the part of the insurance company to discredit the evidence of the claimant in any manner. So there is no perversity in the judgment lodgment, and there is no scope for interference. Because 163A as to payment of, I'm just reading the particular provision law sheet. Notwithstanding anything contained in this act or any other law for the timing in force or instrument having the force of law, the owner of the motor vehicle or the authorized insurer shall be liable to pay in the case of death or permanent disability due to the accident arising out of use of the motor vehicle. So the use of the motor vehicle is very much their lordship. Compensation is indicated in the second schedule to the legal heirs or the victim as the case may be. So that was the rightly decided by the learned tribunal, and accordingly the compensation was awarded. So this is the thing, lordship.
If I can just say ration negligence, lordship, we are not denying that the accident took place. We are not denying the accident. There is no denial of the accident. Only thing the legal provision that are involved. That's all. And also the fact that we have already paid him 2,33,000, but the disability amount, lordship, disability amount of rupees 2,59,200. No way he will be entitled to. That is Rajkumar Ajay Kumar very clear.
Okay.
So,
Or Ms. R.D. Mazumdar, learned counsel for the appellant, and Mr. Chaudhary for the respondent. Argument concluded, order adjourned.
are you obliged? But
May it please your lordship. In this case, what happened, your lordship? The petitioners initially filed a title suit for partition, which was initially dismissed, and against that, a regular first appeal was preferred in the year 2016. And the RFO was preferred before this court because at that time jurisdiction, pecuniary jurisdiction was something different. So against the title suit that was dismissed, which was a partition suit, an RFO was preferred before this honorable court in 2016. But in the year 2021, lordship, no pecuniary jurisdiction has been amended. And so this honorable court transferred the matter back to the court of district judge for final adjudication of the matter. And accordingly, the court case was assigned to the court of additional district judge for adjudication. The case was renumbered as title appeal number 3 of 2022. And the case was heard at length on various dates. And ultimately, on the learned additional district judge fixed 24/2/2025 as the date for pronouncement of judgment in the appeal. The learned additional district, after hearing the parties, fixed 24/2/2025 as the date for pronouncement of judgment. In the meantime, your lordship, the respondents had filed a petition seeking withdrawal at page number 10. I have annexed, your lordship. And the allegation and the very casually filed and nothing substantial, just at paragraph 3, lordship will see at page number 12. Just before the pronouncement of the judgment, this. May I read your paragraph 3 at page 12, that for some oral observation of the Honorable Additional District Judge during the time of recent hearing on petition for appointment of receiver and other external reasons, the petitioners are apprehending that they may not get justice. And on this, your lordship, they have sought that the case needs to be withdrawn.
No, whether it was written now.
Immediately, lordship, the learned additional district judge has passed an order without issuing notice. We were not aware at page number 15. The case, all the case record has been called to the court of learned district judge. And on 24/2/2025, when we appeared before the ADJ for next page, page 16, your lordship. We appeared before the ADJ for delivery of that order. On that day, your lordship, we came to know that the contesting parties, the DG has passed in order, the contesting parties are duly represented. Since the requisition number so and so by the Chief Administrative Officer, Office of the Honorable District Hailandi calling for the instant case record in connection with so and so, in view of the above, the judgment could not be delivered today. Just before the pronouncement of the judgment, Your Lordship, they have filed a petition alleging these things, and the learned
Whether any order was passed by the district judge.
at page 15, Your Lordship,
Is 15
What-
call for the record.
record has been called for. Virtually it
Thereafter?
has, and thereafter, Your Lordship, at page 17, Your Lordship, on the next date, that did not appear, Your Lordship. And again, the case has been fixed on 21/3 for hearing, Your Lordship. No notice, nothing was given. It is particularly,
No, practically, the district judge has not passed any order for transferring the case.
practically not, but without issuing notice, he has already called all the record, Your Lordship. Once the record has been called prima facie, he has gone into the allegation. Otherwise, he ought to have issued notice, or he should have stayed the further proceedings. Only on vague allegations that we have some doubt that we may not get justice. In this
No,
way,
that's all right, but till date, the district judge has not withdrawn the case from your court.
from the
So
court,
he has called for the record.
a final order has not yet been issued.
Then
But this order of 29/1 calling for the record, this is also not permissible under the law, Your Lordship, in view of section 24 CPC.
no, let the district judge pass the order. The case is fixed on tomorrow. We keep the matter pending.
Lordship, that is also.
So unless the order is passed withdrawing the case from your court. So this order by which the record was called for cannot be challenged, correct? 29/1/2022. Because district judge has the power to call for the record.
Now, if so,
But before passing the final order, definitely he may hear you.
Lordship will fix the case then on the next week, Monday or Tuesday. In the meantime, let us see what the order is there.
Heard Mr. M.A. Luskor, learned counsel for the petitioner.
Lordship.
Leaves the matter after a week on 26.
Right, Lordship. Oblige, Lordship.
May please your lordship. Which matter may be taken after sometime. Senior is election court number 4. Lordship, it may be adjourned for time being. Lordship.
Let him appear.
Which case CD not received lordship. Notice also we have not received any instruction regarding notice. POXO case lordship.
Notice not received.
Notice service report is awaited lord. Moreover,
Case diary received.
CD not received.
Lordship petitioner behind the bar, Lordship 40 days, Lordship. 40 days. Lordship next week any date, Lordship.
Mr. K.K. does learn additional PT submits that he has not received the case diary and also not received the service report from the jurisdictional PS. Accordingly, it is provided that Mr. Das will produce the service report and also the case diary before this court on
27 lordship.
27. Okay.
Ma'am.
Maybe 20. Isn't
LCR.
my lord, the LCR was called on from the last occasion.
It's a received or not received?
Not received, Lordship. LCR not received, but one status report is there, Lordship. That is dated 10/3/2025, Lordship. According to it, Lordship, there are 5 evidence, 1, 2, 3, 4, 5 PWs were recorded. And next date is 1/4 and 2/4 for evidence. And total.
One, 5 witnesses are examined.
Examine, Lord. The next date is 1/4 and 2/4. It is on status report is there.
So somehow whether this petition will be maintainable, because the Supreme Court stated that if trial is not started, now trial started, 5 witnesses.
Yes, my lord. Trial has started after the charges being framed, my lord. But my lord, what I'm pressing here is, my lord, the section 37, the twin conditions, my lord, and the Article 21 of the Constitution. My lord, a similar, in fact, my lord, similar kind of a case raising from the same police station, this Honorable High Court was pleased to grant bail, my lord. However, I'm just pressing it on, my lord, for record, my lord. In fact, in this case also, 3 evidence were.
So as per order of the Supreme Court,
Yes, my lord. Although the Supreme Court said the trial does not commence within 6 months, then I'm allowed to. But my lord, may I just observe this, my lord, that there's a similar order, similar case which was pending before this Honorable High Court.
no, now your case is different from other cases.
No, my lord, my lord, may I just submit here, my lord, just 1 minute, ma'am. I absolutely understand what's fallen from my lord, and in fact, on the last order also, my lord has recorded that the evidence has, my lord, my last order of Lord's order, my lord, which was rejected, my lord. I absolutely understand what's. My lord, at page 20, my lord, page 153, paragraph 20, my lord. However, the learned court below is directed to expedite the trial and conclude the same at the earliest possible time without being influenced by any of the observation made by this court herein above. And if necessary, the learned court below shall take recourse to provision of 309(1) of the CRPC. My lord,
So that's all right.
Yes,
Now,
yeah.
the court has already examined 5 witnesses.
yes, my lord, absolutely, my lord is absolutely right. on that.
Let the scan copy of the record come with.
My
How
lord,
many witnesses are cited in the search?
10, my lord.
10. 5 have been examined.
Yes.
Moreover, the cases were also split up on 26/6/24, so that trial becomes fast, Lordship. Because one of the accused not appearing, Lordship.
Not appearing, he's absconding.
That is why it's split up.
Both the one
5
accused.
has already been examined, Lordship, and next date is 1/4.
Okay. Heard Mr. Sharma, learned counsel for the accused, and also heard Mr. Kedas, learned additional people for the status. Office note dated 19/3/2025 indicates that scanned copy of the record has not been received from the learned trial court. Raises a lesser reminder to the learned trial court to transmit the scanned copy of the record without further delay. Is the matter accepted?
4th of April,
Sorry.
28 April, March.
28 March.
28th March.
Lordship, next date is 1/4.
Before the trial court.
Oh, yes, sir. Okay. Then after that, it will be better, Lordship. Then.
Okay.
26
No, it has to be after.
April,
April,
after 3rd of April.
7th of April.
7th of April.
7th.
Okay. 7th of April.
I apologize, madam.
Item number 4. Item 4.
It was fixed for CD lordship. IU has made a prayer lordship that they received a message on 19. So another date maybe fixed.
Mr. KK does learn a additional duty submits that. He has not received the case diary. And the IO prayed for granting some time to produce the case diary. For where is the law? This is the matter on. When?
27.
27.
27.
5 and 6.
Item number 5, I have received instruction, madam. I'll file affidavit with it.
Item number 5.
I will take it,
Five and six is correlated.
Okay.
5 and 6 is correlated.
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 Let them file.
Madam.
Yes,
Yes,
sir.
madam. Date may be fixed, madam.
One week
No, no, madam.
after Bihu.
Yes,
No, it is,
better. Frequently you are there taking time
But-
there. How many time to take
madam,
time?
he is in position, safety position, madam.
You are
So
of
he
safety
is-
position.
no,
You are of
no,
safety
my
position.
lord, no.
We have been promoted by
I have
headmaster.
challenged his
He's not going
appointment,
there.
my lord.
He
I
wants
have
that
been
he
transferred
said
from
to
another
the-
school, my lord, that your lordship grant the stay, my lord.
Yes.
I am claiming the post of the headmaster, my lord. That matter is still pending, my lord.
But the authority as well, Government of Assam has given him
lord,
the headmaster post in different
My
school.
humble
He's not
submission, my
going.
lord.
He said, I
Short
want
date
this
may be
school.
given, my
Is
lord.
there any law like that, my lord?
I
That I
have
have to
seen,
work in
One
the
by
same.
one by one. One by
Yes, yes.
They're fighting on the beneficiary. And my friend asked for 2 weeks. If it's 2 weeks, then automatically it will come up from the view.
Hmm.
So, we will try before Bihu then.
yes, madam.
Third Mr.
R. Islam.
R. Islam, Learned Counsel for the petitioner. And you are petitioner in
Item 5.
Item 5,
item 5.
and respondent number
In IA,
in I am applicant. I is applicant.
Acha. Mr. Biswas, you?
I mean, item number 6, my lord.
Mr. Biswas, item 6. Mr. Pegu, Learned Counsel for the respondent, state respondent. Submits that he has received instruction and he will file an affidavit and request for granting some time. There is accordingly allowed. And Mr. You or respondent number?
For R5.
What?
For R5, man.
R5.
Yes.
Your good name, please?
Yeah, within, man. Jamila with.
Okay. Leave the matter on.
Let it be on 9.
Okay.
9.
For Bihu. Nine.
Oblige.
So criminal, this civil revision petitions having two eyes also. During the civil revision petitions, the one of the defendant and expired. So we have filed two application for substitution and abatement of this application.
Come one by one.
If you
I number 3686. This is for what purpose?
for limitation, Your Honor.
What?
Limitation for condemnation of filing the application for substitution of legal heirs of respondent number 4. In CRP, in civil revision petition 360, the respondent number 4 has been added as party defendant, party opposite party number 4, and during the proceeding of the civil revision petition, on the strength of the office note of the civil revision petition, we came to know that the respondent number 4 has been expired, and he has been added as main respondent, main defendant in title suit in as well as in title appeal, which is still pending before the learned court below.
So, any objection?
My lord, let him to finish. Totally. Is a delay of 4,080. He has filed the appeal during his suit. His suit he has lost this family partition case. I'll not say now. Let him to finish. I'll not file anything. He has filed the appeal in the year 2014 against the death person. 4,000, if it is, he has come to know in the year 2019. Supposing that respondent number 4 is expired. 4,700 is how many years? Minimum 10 years, almost 15 years, minus 2019, 15 years. It will be not 2007 or like this. He has filed his appeal. He has lost his title suit in the year 2014. It is proceeding 2014. Then he has come another interesting job. The court has passed the order for uh, uh, for legal years of my father. Already in the title suit, he has included the legal years of my father and my 3 brothers. It is in 2006. Then again filed. My lord, if I want to say, submit, kindly see. See, very interesting. Court has dismissed this petition because they have not filed for substitution, filed a condemnation petition. If it is 1 day delay, 1 day for petition has to be submitted. That is a delay of 9 months. He is taking the stay in the year 2015 by this petition.
Okay.
Last 10 years.
Let him first argue.
Lordship,
That is why let him to.
we have filed this application, and your lordships, I will go to the annexure A, page 11. During the civil revision petitions, page 12, it is important. Heard Mr. Learned H. Borua, Learned Counsel for the petitioner. I have also heard Mr. R.C. Paul, Learned Counsel for the representative 1, 2, 3. From the perusal of the office note, it is transparent that the service of notice, it is this case is completed on respondent number 5 to 9, which fact has not been disputed by the Learned Counsel for the either party. Office note, it is important. 27 to 17 further indicate that the respondent number 4, that is Suryakanta Boro, has expired. On that, from the office note and the order pass, we came to know that this person has been expired 2018. So immediately after knowing that about the fact that the death of that person, we have filed this petition. The limitation 120 Act has said that from the date of the death, it has been counted. But I will produce the judgment also that from the moment you have known the fact that this person has been expired, then the condonation or substitution though it has been long delay, it should become condoned. The Honorable Apex Court has rightly been pointed on. I will place on these facts before the Honorable Court, Your Honor. The first thing is that the court order on 25/4/8/2018, we know that this person has expired, and immediately after knowing the fact, within a month, we have filed this application, also annexing the death certificate and the grounds for which we are sufficient cause for not filing this substitution petition and condonation delay, we have been asserted in our petition. That is why we, for the purpose of the very necessity of the parties, the respondent number 4, it should be, his legal heir should be imputed as party respondent. Now, Your Lordship, if you in application, we have categorically stated why we have delayed. Though we came to know that about the fact that he has been expired on.
So, which paragraph of your petition you
Yes.
mentioned it?
Yes. Yes, paragraph number 8, page 7, we categorically stated The petitioner applicants respectively stated being agree with the interim order dated 27/5/2015 passed by the learned Court of Civil Justice Amingaon have moved a civil division petition bearing number so and so before this Honorable High Court. It said by an order dated interim order dated 24/8/2015, this Honorable High Court, while issuing notices upon the respondent opposite parties, also provided interim protections to the petitioner applicants. The petitioner applicant number 9, paragraph number 9 states that the applicant took steps upon the respondent number 1 to 9 on 5/10/2015 and the subsequently respondent number 1 to 3 had entered appearance in the instant matter through their counsel. Moreover, on 25/4/2018, the instant case has been listed before this Honorable High Court, and the office note dated 27/2017 reflects that the service upon the in this case was completed on respondent number 5 to 9, but service upon the respondent number 4 could not be completed due to death of the respondent number 4. Subsequently, learned counsel for the petitioner, after coming know about the death of the respondent number 4 from the order dated 25/4/18 passed in CRP number so and so, immediately intimated about the death of the respondent number 4 to the petitioner. We have intimated and asked them to obtain necessary document instructions for filing the necessary application for substitution of legal heirs of the respondent number 4, as directed by the learned by this Honorable Court. The petitioner tried to collect the information and collect the documents of such death certificate. It is important. And regarding the date of death, name, age, and address of the legal respondent number 4, and could collect the same only 2 days back and after giving much effort for obtaining the same. Moreover, the petitioner were totally ignorant about the death of the respondent number 4 at the time of filing of the aforesaid title appeal and during the pendency of the title appeal before the learned Court of Civil Justice Amingaon and the learned Additional Court of District Judge Rongia. It will be relevant to state here that the relationship between the petitioners with the respondents are not cordial, and several issues indicated had happened prior to the filing of the suit till date. Thereafter, petitioner immediately come to Guwahati to meet his counsel to file necessary application before this Honorable Court. That the number 10, that the petitioner humbly begged to say that the petitioner could come to know about the respondent 4 so and so expired after intimation from his counsel. Petitioner were not aware of the fact of the defendant 4 earlier, as they were staying in another place since several years from the original place of residence. As such, application for respondent 5 limitation had filed by the petitioner applicant for condemnation so and so, filing application for Borough, who died in 25/7/2007 is filed along with an application for setting aside abatement and substitution for legal heirs of this respondent 4. No, Your Lordships, I will draw out this some of the judgment also. Why?
My lord.
Let him complete.
Yes.
What is happening in filing this?
So you came to know about the death of respondent number 4 only on 25/4/2018.
18. It is not a trial or pending before the Honorable Court when the day-to-day matter has been come up before the trial court. Now, in pendency of this civil division petition before the Honorable High Court, and when the listing has been listed the matter after a considerable time, we came to know that after completion of service, this respondent number 4 has been expired. The Honorable Apex Court has well versed. Yes. In a judgment rendered by the Apex Court in 2008, 8 SCC 321, one of the vital parameter has been laid down and it has been clarified. When an appeal is pending in a high court, dates of hearing are not fixed periodically. once the appeal is admitted, it is virtually goes into the storage and listed before the court only when it is ripped for hearing or when some application seeking an interim indirection is filed. It is common for appeals pending in the High Court and not to list all.
You come to the point.
Yes. The High Court has overlooked the await appeal and the litigant is no way responsible for non-listing of the several years. There is no need for the appellant to keep track whether the respondent is dead or alive by periodical inquiries during the long period between the admission and listing of hearing. When the appeal is kept in pending, is suspended animation for a large number of years in the High Court without any date being fixed for hearing, there is no likelihood of appellant become aware of the death of the respondent unless both live in the immediate vicinity or were related, or the court issue a notice to him informing the death of the respondent. In this case, we came to know in 2018 that this person has been expired from the office note, and court has directed to substitute the legal heirs of the respondent number 4. So, so is the whether the counsel of the deceased respondent or the legal heirs of the respondent were notified the court about the death and the whether the court give notices to such death of the appellant. Rule 10A order 22 cast a duty. That is another factor. Is that it is order CPC rule order 22 rule 10 has cast a duty upon the counsel to give a intimation to the court that the person has been expired, and on that very day, if the court notify a notice and send a notice to the party concerned to implead or substitute it, then the matter has to be followed. Now, in this case, when the person has been expired during the revision petitions application pending before the honorable court and office note, that outrightly this the delay has to be gone down. It is a parameter laid down by the honorable High Court in the apex court in Chinnamal versus P. Argumangam case. It is, I will submit a judgment. It is well to remember that CPC is a body of procedural law designed to facilitate the justice and not should be treated as an enactment providing for punishment and penalties. The law procedure should be constituted as a render of justice whenever reasonably possible. It is our opinion not unreasonable to demand restitution from the persons who has purchased the property in the court auction, being aware of the pending appeal against the decree. Oh, the procedural aspect has to be no way come to the court for the justice.
When the respondent number 4 died,
Respondent number 4 has been expired. At the death certificate we have received on we have annexed 27/5/2007.
where is that certificate?
Page number 15, annexure B. After collecting the this death certificate.
So according to you, this limitation period has to be counted from the date of 25/4/2018.
18. From the moment the court has notified that this person has been expired, and the apex honorable
So
court
only on that day it came to your notice that the person concerned has died.
died.
Yes, you produced the judgment.
Yes. One of the vital judgment, your lordship, this rendered in this on 11 February 2025. The 11, 17, and 50. How do
So this 2019, 1990 judgment, which paragraph you have relied
So,
on?
Your Lordship, this on 20, it is a judgment, Om Prakash Gupta alias Lalua.
No, no, that's Sinapal and others versus Arumugam. Arumugam.
Yes. Number two, it was. Yes, in number. Yes. Yes, paragraph number 17. A few lines. It is well to remember that the Code of Civil Procedure is a body of procedural law designed to facilitate the justice.
Yes, Mr. Pal.
Madam, kindly, after coming, maintainability of the CRP.
No, now we are
Madam, kindly
on
see, the
condemnation of this delay.
CRP is pending last 10 years. Yes, took the stay order against which order? I'm not, it is the lordship. Kindly see this last page. That the suit was filed in the year 2006. Judgment was delivered. His suit is dismissed on contest on 20th of December
No,
2010.
no, you first come to this interlocutory application. 3686.
Well, I think the interlocutory application, I have not filed any objection because it is a case, my lord, kindly see, it is a case he has come to know in the year 2019. He has filed the case, very small submission, my lord.
Mm.
He has filed and he has lost his case. Lost his case if it is the person, respondent number 4, died in the year 2007. 2007. Judgment is delivered 2010. Title should registered in the year 2006. Proceeding is going on. During that time, he has no knowledge. 2007, title suit 66. 2007, expired. Respondent number 4. Judgment was delivered against the dead person. He has lost his case. 2010. He has filed the appeal. Then,
When the judgment was pronounced?
my lord, page kindly see, a main CRP. He has annexed this judgment.
So that's all right. You tell me on in which year it was pronounced.
Pronounced, my lord, 20th of December 2010 by the
20th of
December 2010. Kamrup Rural, my lord, Rongia. Then they file an appeal. Title appeal 2014. Next page number 36. Then they filed an on petition for substitution. For substitution, whose substitution? Substitution of my father. I am the legal heirs of father. Already my names, we are the 3 sons. Already it reflects in the petition, my lord, CRP. My fathers, they have made the party. It is a family partition case. I do not know how it is a inherent property. He has made the party. My father with a son. Although, all right, proceeding, then expired. Then expired in 2006. Then my lord, kindly see petition, main petition. I'm not filing. Page number 20 is still written. This is the vernacular, my lord. 11 of 2006, title shoot number. On the left side, my lord. checked. Bhubaneswar Boro is my father. Bhubaneswar Boro, myself, I'm the son, and Thokram Boro is my father. I'm the party. We are the legal, we are the son of the, they have made the party. Now they come to know that they filed a petition for substitution. Kindly see my lord, last page, page number 47. There is no 47, the order, impugn order, according to him. My lord, may I read? This order itself reflect, there is a 3 page only. Order dated 27. Against this order, he has filed this CRP. 27/5/15. Both sides are present. By this order, I dispose of the petition filed by the appellant under order 22 to Rule 4. And I do section 151 CRP 24 and the substitution of legal areas of the program borough. My father was already expired. My father is expired. My name is already there. They have made the party. Very interesting. Case is very interesting. I have already heard the submission placed before the learned council, both the sides. We filed an objection also there. The case of the appellant are that they have filed, appellant means here is petition, filed the instant appeal against the respondent being aggrieved by the judgment and decree passed by the Muntif at Tungia in connection with the title suit number 11 of the 06, and according the instant appeal is pending for disposal before this on court. It is stated by the appellant that the advocate for the respondent on 11/6/2014 has filed 2 documents before this court. One death certificate 14, one death certificate of the Tokram Boro. Tokram Boro is my father. Respondent number 1 will become the respondent number 1. I'm representing the Tokram Boro since he is expert. We're representing the 3 brothers, myself. Respondent. Here in respondent. 11/6/2014 has filed 2 documents before this court and death certificate in respect of Tokram Boro, that is respondent number 1, and other is the list of family members for the Tokram Boro. And accordingly, this court was pleased to pass order on 11/6/2014 directing the appellant to take steps to substitute the names of the legal heirs of late Tokram Boro in respondent number 1. It is claimed by the appellant that only 12/6/2014 death of Tokram Boro came to their knowledge as the same was informed to them by their engaged advocate. It is also stated by the appellant petitioner that out of 13 numbers of family members in respect of Tokram Boro, respondent number 2, 4, and 3 respectively in the instant appeal, however, as the right to choose still survives against the legal representative of Tokram Boro. So the remaining family members of Tokram Boro is shown in the list submitted by the respondent side on 11/6/14. The record to be completed, substituted as party respondent in place of the Tokram Boro, and that the following persons mentioned in the list submitted by the respondent are required to be substituted. They are Vinita Boro, sister Vinita Boro, my sister, as that petition. To this effect, one is very important this time. Respondent submitted their written objection, wherein they contended that the petition filed by the appellant petitioner for substitution of their legal heirs of the deceased Tokram Boro is barred by law of limitation. Suppose he has got the information, but he has not filed for substitution delay petition. That is why court has rejected ultimately. This is a defective case. He himself has made a defective. Coming. This is very good findings of this tribunal. Below. The Tokram Boro is barred. The Tokram Boro is barred by law of limitation as the appellant has have not filed the petition within the period of limitation. They got the, suppose 2 months back, I have informed before this honor because this is my father is expired. So you have to substitute along with the condemnation petition, but they have not filed the condemnation petition, even already awaited. He's saying that before this honorable court, I am not informed. It is clear in the this order. It is. I'm not going to say matter regarding the response number 4, regarding response number 1. Response number it is a
No, this application is for
No,
implementation
Madam,
of
can I-
legal heirs of respondent number 4.
I'm coming the maintainability of this case. What the case
No,
remains.
no. You first come to this
But
petition.
that is why I'm coming. That is a coming because response number 4 expired in the year
No, we are
2007.
not hearing the revision petition on merit.
Because it is 10 years, my lord. Already stay.
No,
This
no.
is a family petition case.
First, this petition has to be disposed of.
I think, my lord, if it is
Only
disposed of this,
thereafter we will hear the main petition.
my lord, main petition, if my lord considered, then
No, no,
everything.
main petition cannot be considered without a
No, that is why I'm coming. Whether the delay petition is acceptable or not. That because they get the information.
First, let us dispose of this petition. Thereafter,
My lord, I'm coming to this
yes.
delay. Delay is, my lord, he has mentioned how many days? To me, my lord, 4,707 days.
Hmm.
2007 expired. A judgment was, trial court judgment was delivered in 2010.
Hmm.
Against that, he said that the respondent is important. He was not informed to ask them because he has made the party. Respondent number always respondent, dependent in the title suit. So it is because their residents are, because it is a family partition case, my lord. Adjacent, both are adjacent. Kindly see that address. My father is, they said, my father expired, they don't know because it is totally adjacent land, my lord. Because it's family partition case.
There is no evidence.
Wait. So, this response number 4 also, nearby. It is a Kamru rural, my lord. It is almost at that time village area. I know this Kamru rural. The things is that 2007 expired this person. 10 is 2010 judgment was delivered, dismiss his suit. Even then, during that time, 6, 7, 8, 9, 10, he has not informed the court. Even they informed us. He has made the party. Then he filed an appeal against the dead person, 2014. Then this review petition, Malek, on the ground of my father has expired, it need to be substituted because they are intentionally trying to drag the case. Nothing other. This judgment, this order against the impugn, according to he says that it is an impugn order. It is not an impugn order, it is a right order. There is no defective. Although, my lord, I informed before this oracle, I given all this information regarding death of my father. Then he has to file, if it is 1 day delay petition. That is why this court is, learned court below is dismissed. What remains? During pendency, then he took the stay order in the year 2015. Then, taking time, whatever may be issued notice, we, my lord, appeared in the year 2017. Then 2019, he come to know after 13 years, that is response number 4 expired. His appeal against the dead person. Very dangerous case, man. This type of case is still pending in the High Court, according to him. And you see whether this type of, my lord, maybe got the information. He filed an appeal. When I file the appeal, I must get the information from my client, whether all the persons are living or not. Now, after filing, one after that, no, he has expired in 2007 before judgment, title suit judgment. On the basis of that my lord, delay application has to be rejected. Because it is a, my lord, delay practice and suppression of material fact, my lord. And you see that last 10 years, my lord, I'm suffering. Family partition case. He took the stay order. Again, it will come again 2 years back for hearing of this petition. This order, kindly see, my lord, that is why I'm reading this order. What is the lacunas, my order? That, my lord, I'm reading.
No, Mr. Pal, we are not on the CRT now.
Just I'm reading only for that because Lordship is interested
No, no,
for
no.
condoning the delay. Why the condone delay?
No.
Delay
We
petition, my
cannot
lord.
spare time to you.
My lord, delay petition.
You come to this petition.
Yes, my lord, I'm coming. Delay petition is not maintained. Because
Not
I verbally submitted, my lord. Because he filed one after another petition, today, tomorrow, this way, that way. Because he has a knowledge. He has a filed an appeal. I have not filed any objection petition, my lord. Although on the basis of the record, says that he expect 2007, he has mentioned it, he has filed subsequently appeal.
No, Mr. Pal, you see, he has categorically mentioned in the petition that he came to know about the date of respondent number 4 only in the year only on
2019.
25 for
My lord,
2018.
kindly ask him when appeal was filed, notice was issued,
No,
whether he was appeared, who was appeared.
where is your pleading to controvert this fact stated in this application?
No, I have not filed any objection petition.
Then
No, I'm verbally submitting that when he filed an appeal, we appear. That, my lord, it is a
so,
general.
Mr. Pal, let us do one thing. Let us conduct the delay. Let us
Well, fix the date.
substitute the legal hairs.
Well, fix the date on
And
27, my
thereafter
lord.
we'll hear the
27.
revision petition.
27, my. Fixed on 27 because it is a 2015. He took the stay order. I'm suffering. It is a family partition. Both are
That's all
brothers.
right, but we have to come to the point.
My lord, I have no problem.
Heard Mr. Borua, learned for the petitioner, and also heard Mr. Archipal, learned for the respondent party. This application under section 5 of the Petition Act 1953 is deferred by the applicant for conducting of delay of 400, 4,470 in filing application for substitution of the legal heirs of respondent number 4. Respondent number 4 that namely let Sujakanta Boru who suffered demise on 27/5/2007. Mr. Borua learned counsel for the petitioner submits that learned counsel for the applicant submits that the applicant came to know about the date of respondent number 4 on 25/4/2018 when the matter was listed before this court with one office note dated 28/7/2017, which reflects that service of notice could not be effected upon respondent number 4 as he suffered demise. Mr. Boru, learned counsel for the applicant, further submits that the period of limitation has to be counted from the date of knowledge of date of the respondent number 4. And since the applicant herein came to know about the date of respondent number 4 only on 25/4/2018 from the office note put up by the registry of this court the, in the in the revision petition, and that the delay in filing the substitution petition of the legal heirs of the respondent number 4 is not intentional, rather it is circumstantial, and therefore Mr. Borua has contended to allow this application. In support of this application, Mr. Borua has also referred to some of the decision of the Supreme Court. One, Simpomal, Sinnamal, and others versus the Arumugam and Canada reported in 1990, 1 SSC 513, and Peruman, number 2 Peruman, Bhagavati, Devaswam, Edinadu, please, versus Bhargavi Amma, certificate date by LRS and others, reported in 2008, 8 SCC 321, and also the civil appeal number. Now also Om Prakash Gupta alias Lalua, certificate now deceased, and others versus Satish Chandra, certificate now deceased, in civil appeal number 1P407 of 2024. On the other hand, Mr. Paul Garnett, counsel for the respondent, opposite party,
1, 2, and 3, not for all.
1, 2, and 3. Respondent number 1, 2, and 3 commits that the revision petition itself is not maintainable, and that the title suit was filed in the year 2006, and the respondent number 4 expired in the year 2007, and the title suit was dismissed on 28th of December 2010, and thereafter the applicant has preferred with title appeal in the year 2014, and that the deferment made in the application that he came to know about the death of the respondent number 4 on 25/4/2018 is false deferment, as the applicant resides near the aforementioned respondent number 4, and the applicant herein have been enjoying the stay order, and he has been and the respondent herein are recovering, and therefore Mr. Pal has contended to dismiss the having heard the submission of verdict for both the parties. I have carefully gone to the petition, the documents placed on record, and also perused the dispute. Also perused the decision referred by Mr. Borua, learned counsel for the applicant. It appears that there was delay of 4,407 days in filing this application, but it appears from the statement and development made in the paragraph number 9 of the application that the applicant came to know about the date of the respondent number 4 only on 25/4/2018. And as such, the delay has to be, as such, the period of limitation has to be counted from the date of the knowledge of the applicant, that is 25/4/2008. And the decision referred by Mr. Borua also strengthened his submission, and taking note of the aforementioned position, and also the decision referred by Mr. Borua, this court is of the view that the delay here in this case is sufficiently explained, and accordingly this court is inclined to allow this petition. Accordingly, the delay of 4,407 days in filing the substitution petition for the legal hearing of respondent number 4 stands condemned. What is the number of other IA?
in IA number 3687, we have made the names of the legal heirs of respondent number 4. Page number 3. IA number 3687, page number 3, we have
Page number
3. Anita Boro, Sunita Boro, Amarendra Boro, and Chandan.
heard Mr. Borua learned counsel for the applicant and also heard Mr. Pal learned counsel for the respondent number 123. This application under Order 22 Rule 4 of the Code of Civil Procedure is preferred by the applicant for substitution of legal heirs of respondent number 4 in civil revision petition number 660 of 2015. Who, who suffered demise on 27/5 of 2007. 27 or 28?
Okay.
27. Okay. 27/5 of 2007.
Today, 7.
7. Mr. Borua learned account for the applicant commits that the respondent number 4 suffered demise on 27/5/2007, and as such, there is a requirement for impeachment of legal heirs of the state respondent number 4. State respondent number 4. And therefore, Mr. Borua has contended to allow this petition. Allow this petition by including the legal heir namely Srimati Anita Boru, Sumita Boru, Amarendra Boru, and Sri Chandan Boru as the legal heirs of the respondent number 4. Mr. Archibald learned counsel for the respondent number 1, 2, and 4. So 1, 2, 3. Submits that he has no objection in the event of infringement of the legal heirs of the respondent number 4. Whereas taking note of the submission of learned counsel for both the parties, and also considering the fact that much of the record is put into time to allow this application, the legal heirs of respondent number 4 be implemented in the civil revision petition number 360 of 2015 as 4A, 4B, 4C, and 4D. In view of the order passed in this IA, the learned counsel for the petitioner in revision petition number so shall file amended subtitle within a period of 3 working days from today. And Grace shall list the CRP for final disposal on
My lord, as early as possible this month,
this month.
because it is
may
10,
possible
10 years, my lord. That is why I read it little, my lord.
First week of April.
1st of April. My lord,
Part of it. Part of it.
3rd of April.
As the matter is of 2015,
My lord,
2015, this item as top of the list item on 3rd of April.
yes, as a first item. my lord.
There's one application also pending, or 3688 for setting an abatement of the
Okay. Okay, we'll allow it.
plot.
My lord.
দাদা
11111, my lord. Annexer 20, my lord. The regulation order was on 11 April 2000. That is the reflected 11 for 2018. And respondents, the director elementary education, total my lord 30 petition, 30 stipendiary teachers were regularized. My serial number is serial number 28, my lord. My serial number at 28. My lord. And serial number,
So
my lord,
this order was given effect to from who is that?
with effect from my lord, from the date of passing this order, my lord. The in exercise power conferred upon the Director of Elementary Education Assam so in pursuance of government letter dated 2008 the following candidates who are recommended by the scanning committee and forwarded by the government letter and subject to the satisfactory police vehicle report hereby regularizes assistant teacher lower primary school on the basis of terminable at any time without notice assigning any reason admissible so and so so and so. And thereafter, my please make kindly see serial number 4. 4, 5, 6, 7, 8, 9, 10, 12, and 25 came after regulation came before the Honorable Court. Please may kindly see the order dated page 114, my lord. 114, my lord, Annexure 21, serial number 4, 12, 9, 8, 10, 6, 25, and 16 for the regulation. They came before the Honorable Court. And Honorable Court, please may kindly go to it, page 117, my lord. Same serial number 4. It is stated those who completed junior basic training as clear mentioned in the appointment letter would be entitled at the time scale of pay from the date of passing junior basic training course, and as such, since petitioner all had passed junior basic training course in the year 2012, I am also 2002, they would be entitled to regular scale of pay attached to the said post. However, same has been guaranteed to the petitioner having not been given pay scale attached assistant teacher in spite of junior basic training, passing the junior basic training course have approached this court. The Learned Council petitioner has stated that issue has been considered this court, Sri Khagen Hazarika, so and so, directing that those who completed junior basic training course would be entitled to regular pay scale from the date of passing junior basic training course. In view of the matter, the court is of the opinion that petitioner would be entitled to regular pay scale attached to the post assistant teacher from the respective date from which they passed junior basic training course. Petitioner have made additional pay to still covered under Assam Service Pension 1969. As regards this petitioner have referred to the decision so Khagen Hazarika so. As regards this claim, it has been submitted the authorities have already declared that those teachers who passed junior basic training course before 25/1/2005 shall not be covered under new pension scheme as evident from order dated 15/3/2010. Accordingly, this court is of the view that since the petitioner had obtained their junior basic training course in the year 2002 before 25/1/2005, their case also covered by the old pension scheme and not by the new pension scheme. With the above observation direction present, after passing this order, my lord, the department, please may kindly see page 119, annexure 22. Page 119, paragraph, last paragraph 120, operative, my lord. In view, you also got it, my lord. In view of above facts, it observed that since the benefit claimed by the present petitioner had already been extended to the similar situated teacher, co-petitioner, therefore, you are requested kindly comply with the Honorable Guwahati High Court order at 30/10/2019 in writ petition 7831/2000. That is a 7831, my lord. Uh, and allowing regular pay scale to the instant petitioner with effect from date of their passing junior basic training course along with area till order regulation 11/2018, as well as the allowing them to be governed under old pension scheme. And thereafter they receive all my lord benefit scale with from the date of passing junior basic training, and also they covered under old pension, my lord. And my lord, my humble submission is that, my lord, at that time, my lord, petitioner could not come along with them, so there will see the right, my lord. I brought in citation before lordship. একটু দিয়ে দিব। The state of Karnataka versus state of Assam, C. Lolita's case, my lord. My lord. Pera, my lord. 24, my lord. Page 756, my lord. Merit, my lord. Para 29. Service jurisprudence evolved by this court from time to time postulates that all persons similarly situated should be treated similarly. Only because one person has approached the court, that would not mean that persons similarly situated should be treated differently. My humble submission is that, my lord, petitioner is not come along with that, my lord. Same selection, same regulation order, all are
So,
coming before you.
you have been first appointed in which year?
To 1996, my lord. Please may kindly see the appointment order, my lord. Pursuant to advertisement, page 44, my lord. 6/12/1999. Subject to the discharge without notice and without assigning any reason, therefore, Bina Setia Fukon, data of so and so is temporarily appointed as stipendiary teacher, madam, and posted at Mondip LP School the following terms and conditions. CL number 1. Initially, she will get monthly stipend of rupees 900 only per month. Subsequently, she will be deputed to the undergo basic training for a period of 1 year, where will get subject to available fund deputation allowances and additional regular monthly stipend. On her successful completion of training, she will be given regular time scale of pay as prescribed in ROP Rule 1990 and other allowances admissible under the rule from the date of announcement of the result, my lord. And pursuant after my lord appointment order, petitioner was sent for training, page 48, annex up 4, my lord. My name is Srimati Bina Setia Fukon. Srimati Bina Setia Fukon, assistant teacher, Mondip LP School.
Okay.
And thereafter completed in basic training, and thereafter they have not regularized in spite of that, and she is receiving only 1,800 per month till 2000 regularization, my lord. And she came before the honorable court along with others, my lord. Page 62, the earlier in 2002 she came. So a similar situated person came, but her number at page serial number 79, page 11, annexer 11, man. Bina Setia Pukon, man. All are coming this, my lord. Others are there, my lord. And serial number 2, Bina Setia Pukon. And honorable court specifically stated that, my lord, having regard to the submission advance on behalf of the writ petitioner and considering the advance made in the writ petition in the interest, it is in interim, it is directed that response number 4 shall not be divert any of the fund released for payment of salary and stipend of the petitioner, and such salary stipend be henceforth paid to the petitioner regular basis. We have received regularly till regulation as 1,800 per month, my lord. And thereafter, my lord, what happened, my lord? There is a scanning committee was constituted pursuant to honorable court's order, my lord. And my lord, please may kindly see the advertisement page, my lord,
Correct.
97, my lord. There's an advertisement, those who are appointment 91 to 2001, they may apply for the verification, and petitioner applied by giving 100 rupees treasury salon, and thereafter, my lord, on RTI page 102, the scanning committee held, my lord. Please may kindly see 102, my lord, your lordship. Scanning case of the irregularly appointment teacher LPM school respect of Tinsukia district. With reference to the government notification cited above, I have the honor to send here with a particular 193 numbers of case irregularly appointed teacher LTUP school, upper primary school in respect of Tinsukia district, which were scrutinized, verified by the scanning committee Tinsukia on so and so. Out of 193, number of 34 cases are regular. My name was in 34, my lord. And please may kindly see,
Okay.
RTI, they says that I am the regular.
Yes.
So thereby, my lord, they regularize us. And
Okay,
all
yeah,
are
what is
receiving.
your
same.
stand?
As earlier said, my lord, the department has sent a para, so I want to file a affidavit of indictment.
No, is the case of the petitioner is not covered by the case of the Purnima Hara?
Seems to be covered, my lord.
Covered.
Seems to be covered.
Then I will pass similar direction to verify her.
After
certificate.
verification, my lord.
Then I give you found, then, found her eligible for getting the old pension scheme.
Yes.
Pension under the old pension provided.
Okay. My lord, similar order as 6993 of 2024 of the Honorable Court.
Yeah.
Finance department is
This submission is there, finance department. After verification, finance department, Mr.
Who
Pujari
is
says.
for finance department?
Now
For
already,
finance department.
our board pujari. Yes,
Call it, call it.
already, my lord, it paragraph, my lord, four is Mr. R. Pujari says that, my lord, those who are 11 for 2018 regulation, this is the 39 regular teacher, my lord. So thereby he says that this is covered, my lord. Because of this, says that Mr. R.K. Borpuzar, Learned Council of Finance.
Please inform me.
My lord, that's similar, my lord, past, my lord.
No. Thereafter, again, they will make submission that this order is passed without hearing them.
My lord.
So
Borpuzar.
after some time, after some
My submission is that, my lord, Purnima Hora as well as Jiban Mohanto, my lord, that may be considered, my lord. Much.
21.
Me, please, your lordship. There is a case under Assam Urban Area Rent Control Act. The concurrent decrees have been passed against me by both the court below. Thereafter, we have challenged this by filing a civil revision petition. And your lordship was kind enough to issue notices on 2011-2024. Thereafter, it came up on 17/3/2025, wherein this honorable court has fixed it for admission hearing on 23/4/2025. Now, after that date, I receive a eviction notice from the learned civil judge, North Lakhimpur, which is at page 8 of the IA.
page number.
Page number 8 of the IA. Title Execution Case number 1 of 2025.
Yes, Mr. Chakraborty.
Here, what I understand from the IA is that they are praying for staying of the execution proceeding. Now, my humble contention is at the very first instance, when your lordship had taken this matter at the motion stage, stay was not granted, notices were issued. Thereafter, my lord, records were of course called for. On the last occasion, that is on 17th of March, this matter came up before this honorable court. Now, it has been fixed on 23rd of April for admission hearing. Records are here, so obviously perhaps an endeavor can be made to dispose of the entire revision petition. That was the order on the last occasion. In the meantime, since there was no stay order in the main revision petition, therefore, the respondent, who is the landlord committee, they have initiated an execution proceeding, and in that they have received the notice. And in the execution case, the date is fixed today.
Date is?
Is fixed today.
It has been fixed today.
It is fixed today. The execution case is fixed today. The following date, the date after the notices were issued. I don't know whether they have appeared today or not. But in any case, my lord, if stay is to be granted, that has to be on merit. my understanding, my lord, is if stay of two concurrent decrees is to be granted, that has to be on merit. Now, whether prima facie they have been able to satisfy this honorable court that they are entitled to stay, because they are not asking for, in the petition, they have not asked for stay till 23rd. In the petition, if your lordship sees the prayer portion in the IA, they are asking for stay till the disposal of the revision petition. Now, to that, I have to, my lord, make an objection, because had they been able to make out a prima facie case, they would have been granted stay at the very first instance by this honorable court. Even on the second occasion when this matter came up on 17th, on that occasion also, my lord, the stay was not pressed upon. The matter has been fixed on 23rd of April. Now, today, if stay is to be granted, my lord, if it is a blanket stay, my lord, that has to be on merit. Now, for that, the matter has to be heard.
Then your lordship may hear the entire matter, because if the stay is not granted now, I'll be ejected from the suit premises, and there will be no use of filing this revision petition. So in that case, the entire matter can be heard, if your lordship pleases. Otherwise, what I suggest.
Can we hear the entire matter?
It's on a very short premise, my lord. Landlord-tenant dispute, where, my lord, there are two concurrent findings. Now, on the first occasion, that is before the trial court, the finding was on the ground of default. The ejection decree was passed. Regarding bona fide requirement, the finding was not in favor of the plaintiff. But at the appellate stage, my lord, on both counts, that is both on the counts of default as well as on bona fide requirement, the court has decreed, the learned appellate court has decreed in favor of the plaintiff. Now, against the concurrent decree of eviction, they have come up before this honorable court. So I leave it up to your lordship in so far as taking up the revision petition is concerned, because already there is an order that this matter would be taken up for admission on 23rd of April. In the meantime, execution case has been initiated because there was no stay order. Today, it's the first date in the execution case. Now, if, of course, my learned friend, I can understand his anxiety that the execution case is now pending. But my only contention is that if they are to be given a blanket stay, that has to be on merit. That cannot be a gratis dicta, my lord, in my respectful submission.
Otherwise, your lordship, I can satisfy your lordship now,
that
or your lordship can do one thing, as it has been fixed on 23/4. Till that date, your lordship may stay the title
Had that
execution.
been the prayer in the IA, I might not have raised
No, no,
any objection.
I'll
But the prayer in the IA, your lordship sees, they are praying for
Okay, then till this
till 23/4.
till this date, 23rd for 2025.
That-
I think
that-
it's date.
But my lord, I cannot concede to that. But my lord,
No, otherwise this petition would be instructed. It has already been.
my lord will record my objection, and then, my lord, if your lordship gives them a stay of the execution till 23rd of April, it is fair enough, because I understand, my lord, the matter is fixed on 23rd. There is an order by this honorable court. So let us, my lord.
And your lordship will also see your lordship's order dated 2011-2024, wherein your lordship has said that it will be considered, it will be taken up, the interim will be considered on the next day. So considering that,
Even now also I'm saying, my lord, if the interim is to be considered, that has to be on merit. It cannot be a gratis dicta. That is my only submission.
Otherwise the petition would be instructed.
Then in that case, my lord,
Decree
on
is executed.
23/4.
on 23,
Not till disposal of this case, but till hearing the
yes,
matter.
that
on
of course, my lord,
23rd for
my lord will make an observation, but my lord, my objection can be
Okay, all right. Hard is a not learning for the applicant and also hard as a property learning
Hold it.
for the opposite part. Interlocutory application under section 151 of the referred by the applicant for staying execution of for staying title application case number 1 of 2025 and for the Court of Law and Civil Division number 2 North of Court. Arising out of title suit number 18 of 2007. Mr. Dr. Learned Counsel for the applicant submits that the applicant has deferred one civil division petition against the judgment and decree caused by the Learned Civil Judge Senior Division North of Court. whereby the learned civil judge senior division Norfolk could have upheld the judgment and decree dated 31/7/2024 passed by the learned township number 2 Norfolk Court. Judgment and decree dated 29/9/2023 passed by the learned township number 2 Norfolk including title suit number 18 of 2017. Mr. Dotto, learned township for the said during the pendency of the CRP number 120 of 2024, the respondent herein, the dignity holder stroke the respondent herein of a respondent opposite party herein has instituted the title number 1 of 2025 before the learned executive court, and the applicant herein has received a notice on when you have received the notice.
I have received the notice on 18/3.
18
18/3.
2025, and the matter is fixed today before the learned executive court, and that unless the aforementioned execution proceeding is stayed, the civil revision petition would be in progress. Therefore, Mr. Dr. consented to stay execution of the proceeding of the title execution case number 1 of 2025 till 23rd for 2025. Mr. Chakraborty learned counsel for the respondent opposite party, however, vehemently opposed the petition. Mr. Dr. submits that while the CRP was filed on 28/11/2024, no interim pair of the petitioner was allowed. The interim pair of the petitioner for staying the execution proceeding was for staying the decree. Judgment and decree passed by the learned first appellate court was not considered by this court, and thereafter the matter was listed on 17/3/2025, wherein an order was passed fixing the matter on 23rd for 2025 for admission hearing. Admission hearing. And if the stay has to be granted, it has to be only on merit, and that there are two concurrent judgment and decree in favor of the respondent number 2. No, sorry, in the favor of the respondent opposite party. In favor of the respondent opposite party, and as such, Mr. Chakraborty has conducted to submission. Interlocutory application. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the document record. And it appears that in the title execution proceeding instituted before the learned executing court number 1 of 2025, the learned executing court has issued notice fixing the matter on 28th of March 2025. Further, it appears that the CRP filed by the applicant herein is fixed on 23rd for 2025. Then, taking note of the submission of learned counsel for both the parties and also balancing the equities, this court is inclined to stay further proceeding of the title execution case number 1 of 2025 pending for the learned executive court till 23rd for 2025. Yes, I stand for the court.
My lord,
Amlesh,
an observation perhaps, my lord, that in the main case, an endeavor can be made to dispose of the revision petition.
on that day, waiver will be met. Finally, here and put up the similar.
My lord, Mr. Borpuzar is not available now, my lord. Taken up on Tuesday, my lord. I think.
Anybody from finance department? No. So
He's-
Sonia is also not there.
Showing the name of Professor R. Borpuzar.
Okay. On
On Tuesday, my lord, Tuesday.
Tuesday. Third, and Bora, third and complete photo. For respondent number. Elementary education part. Residential is the matter on Tuesday. Yes, ordered.
Showing the name of my lord.
Okay. Residential also reflect the name of Mr. R. Borpuzar, or extending council part. In that context.
My lord, matter be taken up as a first item, my lord, because of the thief time.
No, this is not a whole matter.
Oh, my. But my
Anyway,
lord,
we'll
part
pick
of
up the
matter,
matter.
so my lord.
Order.
Hearing item number 8 and 9. Madam Secretary.
I had advanced mostly my part of the argument here.
Mm.
Would your lordship want me to recapitulate, or I can reply after they finish?
So your contention was that non-consideration of pleadings by the first appellate court
Right.
amounts to perverse.
Right.
That is your.
Then a couple of few more points. You know.
What are the other points? Please state the same.
My lord, here, in fact, I'll just so because there's a long chain of title, I'll have to trouble your lordship with the exhibits a little bit. There's a long chain of title. Now, both the plaintiff and the defendants are staking claim over patta number 25, dag number 57. I'll just give for your lordship convenience.
What the number?
Patta number 25, dag number 57. Now, both the parties are staking claim over this particular land, and both the parties have claimed that they have purchased it through various intermediary purchasers. So there are two long chains of title for either of the parties. So I'm trying to indicate that in that list, my lord. First, your lordship finds the first page is the plaintiff's chain of title.
Hmm.
Now, 1974-1786, Dondiram Kumar and Roheshwar Kumar were the original pattadars according to us now. To substantiate that, we have the chitta. We have shown that they are the recorded pattadar. Now, they died and their legal heirs, Ananto, Arun and Jagadish appointed Ranjit Kumar Dey as power of attorney, that's as their constituted attorney on 16/10/1996, that is Exhibit 2. Based on that power of attorney, Ranjit Kumar Dey, the attorney, sold 1 kotha 5 lachas, that is the suit land, to Ravi Paul. Now, on the right column, your lordship will find Ravi Paul. There's a sale deed, there's a rectification deed. His name was entered in the Kacha Patta. He has land revenue paying receipts. Now, Ravi Paul then sold it to Subhas Das. Subhas Das then executed a power of attorney in favor of Sumon Das, and Subhas Das, through that attorney, eventually sold it to the plaintiff. Now, if your lordship sees,
In the beginning, 1974 to 86, it was
Dondi Ram Kumar and
Kumar.
Roheshwar Kumar.
Rajeshwar Kumar.
They are
They are
the
the original owner.
original owners. They are recorded also in the
Recorded.
in the revenue record.
And in the year 1996, they are
They-
legally represented.
Representatives appoint Ranjit Kumar Day as the constituted attorney.
Acha.
That is there on record. Then, so therefore, Ananda, Arun and Jagdish through Ranjit, they sold it to Ravi Paul.
Yeah.
1998. So Ravi Paul held the land from 1998 to 2004. So he has sale deed, rectification deed, which I'll address, Kacha Patta, land revenue, paying receipts, everything. His name is recorded. Then Ravi Paul sold it to Subhash Chandra Bose, Subhash Chandra Das, I'm sorry, on 3/8/2004 via another registered sale deed. Then Subhash Chandra Das appoints Suman Das Gupta as his constituted attorney. And then on 17/12/2007, Subhas Das eventually sells it to the plaintiff. Now, plaintiff has registered sale deeds. He has a mutation certificate. His name is recorded in the draft Jama Bandi. And most importantly, he was allotted a separate patta being periodic patta number 50. Now, this is our flow of title. Now, if your lordship may kindly skip over to the next page. Defendant claims.
1 minute. So Abhishek Saha is the second appellant.
Yes, Abhishek Saha was the plaintiff appellant.
Yes, second page.
Now, second page, defendant claims, my lord. Those exhibits have been marked also in the record, my lord. I'll just they say Nondiram Kumar was the original owner. However, there is no document on record that to show his title. Nondiram Kumar, according to them, is the original owner, but there is no supporting document to that effect. Now, my lord, 3/1/1951, Nondiram Kumar, according to them, sells of 8 bigha, 2 kotha, 2.5 lechas, and the dag and patta numbers your lordship will mark is dag number 63 and patta number 61. These are two separate dag and patta. This is wide exhibit A. Now, 18/3/1983, my lord, they say after Nondiram sold it to Satya and Narayan Ram Kumar, Satya Ram Kumar and Narayan Kumar sold it to Dondiram Das, 1983. Now, in this particular sale deed, my lord, I have marked the exhibits. They are saying old dag number 63 and new is 67. And they are saying patta old is 61 and new is 25. Now, to show this transition that 63 dag has become 67, patta number 61 has become new patta number 25, there is absolutely nothing. Then 4/5/1984, my lord, Dondiram and Anwar Hussain, they sold it to Sunil Kaur and Boloram Kaur, according to them, White Exhibit C. Now, 28/3/2005, eventually they say that Sunil Kaur and Boloram, this is a typographical error, Boloram Kaur sold it to the defendant. Now, my lord, first of all, my chain of title is correct as the trial court has already observed that I have shown from all the registered instruments. First of all, the original owner's name is recorded in the revenue records. The intermediary purchasers' names are recorded in the revenue records. And eventually, after my sale deed, my name has been recorded in the revenue records. In fact, I've been given a new patta. 1 kotha for 1 kotha 5 lechas, which is the suit plan. Now, first of all, my lord, if your lordship compares their claim versus mine, my lord, first of all, there is no document to show that the original title vested in Nandiram Kumar. Now, in fact, all the revenue records that have come on record have clearly depicted it is Dondiram Kumar who was and Roheswar Kumar who were the original owner. Now, where from Nondiram Kumar, according to them, became original owners, there is no documentary evidence on record. Now, second fault that I try to find with their chain of title is Nondiram Kumar had sold the land in Dag number 63 and Patta number 61. Now, whether Dag 63 and Patta 61 became Dag 67 and Patta 25, there is nothing on record. That's how that transition of Dags is not there. Now, lastly, my lord, all these intermediary purchasers, be it Satyaram Kumar, Narayan Ram Kumar, Anwar Hussain, Dondiram Das, Sunil Kaur, Bolaram Kaur, none of their names were recorded in the revenue. So to put it simply, my lord, they have failed to show the antecedent title of their vendors. And secondly, my lord, they are from the records, it doesn't appear that they are recorded pattadars, any of them. And lastly, there is no connection to the suit Dag and Patta, which is 67 and 20. Now, based on this, my lord, trial court comes to a categoric finding that our chain of title is duly proved, whereas
So it is declared in your favor.
it was decreed in my favor. It was subsequently
the appellate court has
reversed. Now, those findings page 63 onwards, if your lordship sees. Oh. 63, my lord. 63.
Of the appeal.
No, this is the
Memo of appeal.
demo of yeah. Now, this is
the judgment of the trial court.
This is the judgment of the trial court. Now, from the top, my lord, sixth line after exhibit 23. In view of the above, it is evident that Sumandas Gupta was the owner of the suit land at the time of selling of the land to the plaintiff. The evidence of the PWs and official witness remains uncontroverted. During cross-examination of the aforesaid official witnesses and PWs, nothing material could be elicited by him which goes in favor of the defendant. How the vendor of the plaintiff acquired ownership has been proved by exhibit 2, 3, 7 and 8. The vendor of Subhash Chandra Das was the owner of the suit land, which is proved by exhibit 3, 4, 5 and 6. The vendor of Subhash Chandra Das, namely Ravi Paul, after purchasing the suit land by exhibit 3 and exhibit 4, mutated the land in his name, which is proved by exhibit 5, that is Kachapatta, showing land revenue in the name of Ravi Paul. Exhibit 6, revenue paying certificate, also proves Ravi Paul was regularly paying the revenue. On the other hand, though the defendant has denied the ownership of Subhash Chandra Das, yet the defendant has failed to adduce any cogent evidence to prove this fact. On the other hand, DW1 in his examination in chief has deposed that the suit land belongs to him and the plaintiff has no right, title and possession over the same as claimed by him. DW1 further deposed that Sunil Kaur, his predecessor in interest, and others who along with Bolaram Kaur purchased a plot of land 2 kata 10 lechas covered by patta number 25, tag number 67 with specific boundary. The predecessors in interest of Sunil Kaur and Bolaram Kaur purchased from Dondiram Das and Anwar Hussain Diwan, both white registered sale deed number so and so in the office of the sub-registry Guwahati. The said Dondiram Das and Anwar Hussain purchased the land from Satyaram Kumar and Narayan Chandra Kumar, both sons of Dhoni Ram Kumar of Maligaon. Satyaram Kumar and Narayan Chandra Kumar purchased the land from Nondiram Kumar, son of Gangaram Kumar of Maligaon, white sale deed number so and so. The defendant bought the suit land from Bolaram Kaur and Sunil Kaur. The sale deed was executed in favor on 28/3/2005, registered on the same day in the office of Paniketi, Guwahati, so and so, and delivered possession to the defendant. During cross-examination, DW1 deposed that he cannot say on going through Exhibit A, B, and C as to who bought whose land. DW1 further deposed he has not produced the sale deed by which Dondiram and Anwar bought the suit land. The defendants have failed to prove that at the time of selling the suit land, the vendors Sunil Kaur and Bolaram Kaur had ownership over the suit land. In plaintiff's evidence, this is important, there is chronological description as to how the plaintiff's vendor became the owner of the suit land, but in the evidence of the defendant, there is no chronological description as to how the defendant's vendor came into possession of the suit land and owned the suit land. The plaintiff has discharged his evidence by exhibiting 1, 2, 3, 4, 5, 6, and 7 and 8, which are in chronological order pointing towards the ownership right of the plaintiff's vendor. On the other hand, defendants exhibit, that is exhibit A, B, and C, are not in sequence, and as such, it is not clear as to how the ownership right of the defendant's vendor was acquired. The defendant has failed to prove how the seller in the sale deeds exhibit A, B, and C became the owners of the suit land. The vendor of the plaintiff, namely Subhash Chandra Das, has become the owner of the suit land by Exhibit 7. So and so. The plea of the defendant is that Exhibit 7 is a fraudulent document, but the defendant has failed to prove this plea by adducing cogent evidence. The mutation of a person in the record of right raises presumption that he is the owner of the land unless the contrary is proved. Exhibit 156 proved that the names of the predecessor in interest of the plaintiff's vendor, that is Dhoniram Kumar, Roheswar Kumar, Ravi Paul, had ownership rights and as their names figured find place in the record of rights. The defendant has not rebutted the presumption by adducing cogent evidence. Hence, Subhash Chandra Das, the vendor of the plaintiff, was the owner, and Subhash Chandra Das sold it to plaintiff through power of attorney, namely Suman Das Gupta. Hence, this issue is decided in favor of the plaintiff. So, these are the findings of the trial. My lord will write.
So any other point?
Now, my lord, I'll show from the appellate judgment, my lord. Appellate judgment took into consideration irrelevant factors as to that it was found in the chitta that there were riots, and if there were riots, agricultural tenant. Then from there, it was deduced that if there are riots, then how was the possession delivered, etc., which was nobody's case. Then again, we had rectified the deeds concerning a boundary. So the court held that why has the rectification executed so late, after 10 years, etc. I'll just point.
Okay, after the break, we will.
Yes.
Hear
With the appeal.
any objection?
No objection.
Oh.
Third appeal maybe. Third appeal.
As agreed by learned advocate.
3rd of April, my lord. 3rd of
3rd of April.
3rd of April.
Okay. Okay.
Obliged.
May I please, Lord?
Ah.
Lord, I am sorry to mention at this stage, Lordship. We have filed an IA today, Lordship, in a MSc appeal, which is listed as item number 17 in tomorrow's list, Lordship. So, Lordship, I am praying to list the matter along with that matter, Lordship, which is listed as item number 17 in tomorrow's. Highly obliged.
So, my lord, like I had shown, my lord, the trial court discussed the respective claims of the plaintiff and the defendant and arrived at a conclusion that their vendors, so-called vendors, were not recorded owners. There was no clear chain of sequence and chain of title. And whereas the plaintiff original owners were also recorded pattatars, intermediary sellers were also recorded pattatars, and there's a clear unbroken chain of title. Now, if your lordship may turn over to the appellate judgment, I'll just quickly take your lordship to page 90.
Page number 90.
90.
Memo of appeal.
Of the memo of appeal. This is part of the appellate judgment. I'll just read the reasons, my lord. Rest.
Yes.
Para 21 onward. Thus, according to the plaintiff, the source of his right, title, and interest has flowed to him as well as to his vendor from the legal heirs of the original owners on the basis of the power of attorney Exhibit 2 executed by the owners in favor of Ranjit Kumar De. Now, from a perusal of Exhibit 1, the Chitta, it reveals that the suit land is a part of the total land measuring 16 bigha 4 kotha 5 lechas covered by Dag number 67 of Patta number 25, which stood in the name of Dondiram Kumar and Roheshwar Kumar, the predecessor in interest of Ananta Kumar, Arun Kumar, and Jagdish Kumar. Exhibit 1 further reveals that Dondiram Kumar and Roheshwar Kumar were the sole pattadars in respect of the whole plot of land. And Ananto Kumar, Arun Kumar, and Jagdish Kumar had executed a power of attorney in respect of the part of the land measuring 3 bigha 4 kotha 7.5 lechas without mentioning the boundary. Therefore, in the absence of 4 boundaries, it is not only difficult but impossible to identify 1 kotha 5 lechas out of total 3 bigha 4 kotha 7.5 lechas. This is one point. I'll come to that. Manoj. Under such situation, the power of attorney holder had sold a plot of land measuring 1 kotha 5 lechas out of 3 bigha 4 kotha 7.5 lechas on 23/6/1998 to Ravi Paul White Exhibit 3 by way of giving a specific boundary in the following way. North 16 feet road, south Ajit Das, east others land, west Purkasta. Subsequently, after 6 years, Ravi Paul had sold the land to one Subhash Chandra Das White Exhibit 7. Finally, Subhash Chandra Das sold the said land to present plaintiff White Exhibit 11 through his power of attorney holder, Suman Das Gupta. Further, it reveals a subsequently White rectification deed, Exhibit 4 dated 18/7/2008. The boundary of the sale deed Exhibit 3 was rectified. Then White rectification deed, the Exhibit 8 dated 18/7/2008. The boundary of the sale deed, the Exhibit 7 was rectified. Thereafter, White Exhibit 12 dated 18/7/2008. The boundary of the sale deed Exhibit 11 dated 17/12/2007, standing in the name of the present plaintiff, was rectified in the following effect. North, land of the landlord; south, 16 feet wide road; east, land of other Dag; west, Ajit Chandra Das. Careful perusal of the evidence reveals that the rectification deed, the Exhibit 4, was executed by Ranjit Day, the power of attorney holder of the original owners, without being authorized by Ananto Kumar, Arun Kumar, and Jagdish Kumar to execute the rectification deed. Hence, it is apparent that Exhibit 4 was executed by Ranjit Kumar Day without any lawful authority. Since the rectification in respect of the first sale deed is not as per law, hence the subsequent rectification deeds will not bear any legal value. It further reveals that the purchasers, including the plaintiff, after 10 years of the execution of the first sale deed, the Exhibit 3, have tried to portray an entirely different plot of land as the land purchased by them through respective sale deeds by way of rectifying the boundaries in the respective sale deeds. That being the position, the case put forth by the plaintiff is not found believable and probable to inspire the confidence of the court. In this respect, learned counsel for the appellant relied on the judgment of so-and-so. In the absence of boundary and area of the suit land, it is not identifiable. Further, in so-and-so versus so-and-so, it was held that in case of conflict between area and boundary, the description of boundary will prevail. Under the backdrop of the above factual and legal position, I am of the considered opinion that even if there was a transfer of 1 kotha 5 lechas pertaining to Dag number 67 and Patta number 25, the said transfer took place merely on pen and paper without the land being specifically identified. For the said reason, after a lapse of 10 years from the date of execution of the first sale deed, the purchasers, including the plaintiff respondent, to rectify the boundary just to establish their right over a plot of land covered by the disputed Dag by way of citing a common boundary. Hence, it is found that even if the sale deeds and pattas issued in the name of the plaintiff respondent, but those deeds in the absence of proper identification of the land under sale cannot confer right title and interest to the plaintiff and his vendors over the suit land, which is apparently not the land shown in the sale deeds of the plaintiff respondent as well as vendor. Hence, this issue is decided against the respondent. So, my lord, first, if I may deal with these findings, my lord. The first finding at page 90 is that one of the original sale deeds, the power of attorney, did not specify the boundary, and hence, and from that it was sold to various parties, eventually in favor of the plaintiff. And hence, since one of the sale deeds did not have the power of attorney did not have the boundary, therefore the suit land is not identifiable. Now, I would say this finding is perverse on account of non-consideration of a very vital document, which is the patta. Now, the plaintiff, in her evidence, my lord, in his evidence, had exhibited amongst others, my lord, a separate patta which was granted to him after a settlement process. which is Exhibit 15. Now,
Uh,
Exhibit 15, the entire DAG has been carved out as 1 kotha 5 letter. So it is not as if Exhibit 15 is concerning a larger plot of land, and among them, one of the pattadars is the plaintiff. Since the entire DAG and entire patta is already given to the plaintiff, and without a challenge to this patta, which is otherwise a document of title, it cannot be said that it is unidentifiable. Why I say so is because of Order 7, Rule 3. Manoj. Now, the entire patta is only in respect of 1 kotha 5 letter. So therefore, we need not really find a boundary because it is already identified in the cadastral map as 1 dag and 1 patta. Concerning only the suit land, which is 1 kotha 5 letter. So therefore, Malad, the requirement of Rule 3,
you are referring to
Exhibit 15, Malad,
exhibit 15 is the patta.
is the patta comprising only of the suit land. It's not an Ejmale patta at all. Now, if it is not an Ejmali patta, then the boundaries are not even necessary because I'm claiming right over the whole of the Dag Malad, and which is why it satisfies the requirement of Rule 3, Order 7, Rule 3.
Yes.
Where the subject matter of the suit is immovable property, the plaintiff shall contain the description of the property sufficient to identify it, and in case such property can be identified by boundaries or numbers in the record of settlement or survey, the plaintiff shall specify such boundary or such number. So the grammatical conjunction used is or. So if it is
mentioning the number will be sufficient.
yes, which is mentioned in the record of settlement or survey. So in the record of settlement and survey, if the land is identifiable by the number itself, then I need not really show the boundaries. Here I have shown the boundaries, but it is identifiable from the number itself. Because in that whole of the cadastral map.
No. If you have shown the boundary, why the observation made by the
No, court, learned appellate court is saying that the original power of attorney, if your lordship has my note, the original power of attorney was for 3 bighas and odd land.
Achha.
Now, the learned appellate court says that this 3 bighas is not identifiable out of the total land which is there. Now, that original power of attorney, irrespective, that was in respect of 3 bigha, 4 kotha, 7.5 lechas. Whereas I am claiming 1 kotha 5 lechas, and this 1 kotha 5 lechas is today a separate dag and patta. So therefore, if it's a separate dag and patta, that becomes clearly identifiable because it's a record of the settlement and survey as is depicted under Order 7, Rule 3. Have I been able to? Now, second thing, Your Lordship, the Learned Appellate Court at para 26, page 91 says, that the boundaries were changed subsequently. The boundaries which were there in the subsequent sale deeds was rectified. Now, rectification was done by the power of attorney holder. Now, para 26 says that power of attorney holder Ranjit Kumar Dey had only, perhaps that is what the appellate court is trying to say, that Ranjit Kumar Dey was authorized to execute only a sale deed. How did he execute a deed of rectification? If I have understood the observation correctly, it says careful perusal of the evidence reveals that the rectification deed Exhibit 4 was executed by Ranjit Kumar Dey, the power of attorney holder of the original owner, without being authorized by Ananto Kumar, Arun Kumar and Jagdish Kumar to execute such rectification deed. Hence, it is apparent that Exhibit 4 was executed by Ranjit Day without any lawful authority, since the rectification in respect of first sale deed is not as per law. Hence, the rectification will not bear any legal value. So perhaps the learned appellate court wants to say that since the power of attorney was for executing a sale deed, and you have already executed the sale deed, now you cannot, without further authority from the owners, rectify it. Now, this falls contrary to the basic principle. There is a power, it is assumed that you will also have ancillary powers. Now, further at page 43 of the memo of appeal, if your lordship has for a moment, that's the power of attorney concern and annexed it.
43.
43, man.
Yes.
43, this is the power of attorney. Now, if your lordship comes to page 44, the powers are enumerated. First is the power to transfer by way of sale, mortgage, so and so. Second is the power to enter into agreement. Third, if your lordship sees, to sign, verify, execute any deed or deeds, agreements where affidavit required for the purpose of disposal of the said land, and to present the deeds, etc., before the competent authority for proper execution thereof. So it's a very wide power. The Ranjit Kumar Day had the unbridled power to execute any deeds that may be necessary for the purpose of disposal of the land. Now, this omnibus power, in my humble submission, will include with sweep the power to rectify. Yes. Now, coming back to the impugned judgment again. Now, insofar as the change of the boundaries are concerned, my lord, obviously there's been a delay. There's been a delay of nearly 6 years. But if your lordship sees the boundaries, it is only a mistake. The dark number and patta number remain the same. Who was figuring in south is now figuring in west. So this minor rectification in the boundary alone will not have the effect of negating my right that had flown from the sale deed. And secondly, there is no time if the parties have to approach a court for rectification. I can understand under section 26 there will be a limitation of 3 years. Now, since both the parties have conquered and they have amicably changed it, I reckon there cannot be, and there is no time limit under the law which says that you can change an agreement or a deed only within a period of time. If none of the parties have to approach the court, then obviously they are at liberty to make necessary correction as may be needed. Now, lastly, the court says from there we can presume that the sales happened only on paper. Now, unlike the claim of the defendants, I can show from the records that all of their names were recorded periodically in the revenue record. Now, it is not a case of, so on the basis of the sale lease, the DAG and Patta numbers, mutations have been carried out. So that is prima facie proof of possession. And secondly, these sale leads are registered instruments. Only thing is, who was figuring in south is now shown in east. And it is not their case that we are boundary man. It is not a boundary dispute. The dispute between the parties is where I say it belongs to Nondiram, where they say, I will say it belongs to Nondiram. They say it belongs to they say it belongs to Nandiram Kumar. I say it belongs to Dondiram Kumar and Roheshwar Kumar. So it is not a boundary dispute. So for the court to believe that this minor change in the boundary can have the effect of basically non-suiting me altogether by holding that it is only a paper document, paper deed. All said and done, there's a registered instrument. There are corresponding mutations, and now I have a document of title, which is the patta. Now another perversity. Now, if your lordship comes to page 94.
Yes.
94, para 35, my lord. pleadings of the plaintiff is surreptitiously silent regarding the status of tenants whose, I'll read from 34, my lord. In the case in hand from Exhibit 1, the chitta, it is apparent that there are 8 occupancy tenants over the entire land. Hence, unless it is shown that the tenancy has been forfeited in compliance with Section 50, it is to be presumed that the land under the disputed dag and patta is still in the occupation of the tenant. Moreover, it is the duty of the plaintiff to prove that the suit land is presently not under khatiyan or that the tenancy has been forfeited, complying due procedure of law, but no any steps has been taken by the plaintiff. My lord, this is altogether irrelevant according to my humble submission, my lord. It was nobody's case that some tenants are there. In fact, they also claim to be in possession. I also claim to be in possession. Appellate court found the chitta and found a note that there are some names of riots included. Then, and my suit is not against these riots. And ultimately, since my names are already figuring as patta holders, whether originally in 1974 somebody's name was included as a riot or not is not cannot be a concern today. Now, my lord, 35 pleadings of the plaintiff is surreptitiously silent regarding the status of tenant whose possession reveals more than 36 years from 73. That is the date of endorsement of the chitta till the filing of the suit in 2009. That being the position, it is held that the plaintiff has failed to prove possession of the original pattadars, not to speak of his own possession over the land covered under patta number 25. Now, paragraph 36, that besides plaintiff's pleading is also silent about his date of dispossession from the suit. Now, this is again a perverse finding because it says that I did not indicate in my pleadings that when I was dispossessed, if your lordship for a moment has page 18, my lord.
18
of the same memo, my lord. That's part of my plain.
Paragraph number?
Paragraph number 11 first, my lord.
Memo of appeal before the appellate court?
No, my lord. Here, my lord. I'm referring to page 18 of the memo of this RSM.
Yes.
Para 11, my lord. Cause of action arose on so and so, so and so. And last, the third last line on 4/4/2009, when the plaintiff was illegally, forcefully dispossessed by the defendant from the suit land and on each and supplement. So there's a clear date of dispossession mentioned. And the narration of how the dispossession actually happened is at page 16, paragraph 8.1. In fact, they got an order of status quo, and I say taking advantage of that order of status quo that was passed on 25/3/2009, on 4/4/2009, I was dispossessed. So this finding that my pleadings did not indicate the date of dispossession is also perverse on account of non-consideration of the amended plaintiff's right. My lord, to summarize very quickly, my lord. First of all, my lord, the findings, with utmost respect, are perverse for non-consideration of the pleadings. And secondly, for the fact that the chain of title of the plaintiff versus the chain of title of the defendant was not considered. Where I have purchased the land from recorded pattadars, intermediary vendors were recorded pattadars, and I myself got a separate patta that was not considered versus their case where they claim that Nandi Ram Kumar was the original owner who sold it to Dandi Ram and Anuvar, who sold it to Satya Ram and Narayan, who eventually sold it to Bolaram, and Bolaram eventually sold it to a defendant, my lord. None of the parties name were there in the record of rights. So the trial court rightly held that plaintiff's case was proven. Secondly, the first appellate court held that the power of attorney holder did not have the power to execute the rectification deed, which is again a perverse finding on account of non-consideration of the powers that were vested by Exhibit 4, the power of attorney. Thirdly, my lord, the boundary description would hardly be a ground to non-suit me, because today I have a separate patta for the suit land specifically, and therefore depiction of the survey number as recorded in the settlement would be sufficient to identify the land. And lastly, my lord, the only fact that the deeds were rectified subsequently without even changing the Dag and Patna number, but only changing two of the boundaries, will not by itself raise a presumption that the sale deeds itself are void. So I'll reply, my lord, if needed.
Sir, I have prepared written argument. My learned friend, my lord, argued that there is no resemblance of my lord tag number and patta number. That, that where from I acquire. My lord, then my lord, I have to, my lord, so lordship, the exhibit basically A, B, C, and I. These are the deeds, my lord. Exhibit are bundled.
My lord, it should be the last bunch. I have flag marked it with two pink flags.
Exhibit A. My lord, this is a deed updated, my lord, very old. 3rd of January 1951. Deed number 22 of 51. Is my lord, Procedure, my lord, is my predecessor. Kindly see, my lord, the tag number and pattern number. 15 Kamor, Nadi, 15 Potta, 15 Dagor, Mood Domain, Ulavida, Sarikota, Path letter. So, tag number is 63. Heretic pattern number 61, my lord.
Where it is mentioned?
My lord, it is mentioned in the settlement. And third, in the third page, my lord, second page, the backside, second page. বিক্রি জমির তফসিল কামরূপ জেলা অন্তর্গত গুয়াহাটি থানার এলাকাধীন গুয়াহাটি গাঁৱৰ মেয়াদী 35 নং পট্টা 35 নং দাগৰ মুঠ 16 বিঘা 4 কঠা. This is my lord.
Page number.
Page number in the exhibit, my lord, this is exhibit A, my lord, second page. Tafsil. Bikri Jamir Tafsil. It will be second page, my lord. Whether you have to go to.
Yes.
Yes, ma'am. Then, my lord, exhibit B. This is a date number, my lord, 2401 of 1982, dated 16/3.
82. Passenger Anwar Hussain and Dondiram Das. Says Setaram Kumar Mela from Setaram and Narayan Chatur Kumar from the left. So Mela, here also I am showing you notice the tag number and pattern number. In the topsil part. জমির তফসিল কামরূপ জেলার গুয়াহাটি সাব রেজিস্টার অফিসার এলাকাধীন গুয়াহাটি থানার অন্তর্গত গুটিকুটি গাঁও রাজনৈতিক সাবেক 61 নং 25 নং পাট্টা সাবেক 63 নং 67 নং ডাগর. So my lord, here my lord specifically mention my lord the old dag number and new dag number, old patta number and new patta number.
Page number?
Page number. It will be the third page, my lord, of the document.
Third page.
Third page, yes. Tafsil, my lord. Third page of the document. Tafsil, my lord. My lord, only showing my lord dag number and patta number from the document.
Third page, page number 133 or 134.
My lord, exhibit P. Exhibit P, deed number 2401 of 82.
Not properly marked. A is alright, it is marked, but B is not marked. Mark it in the record. No, Mr. Sohan,
My
you
lord.
mark the other exhibit also, with you will rely upon to argue the case.
My lord, the exhibit B, my lord. Third page, can you see, my lord? Yomir Tafsil.
Yes.
My lord, I am reading Yomir Tafsil. Only the so my lord tag number and pattern. কামরূপ জেলার গুয়াহাটি সাব রেজিস্ট্রি অফিসার এলাকাধীন গুয়াহাটি থানার অন্তর্গত গুটিকুটি গাঁওয়ের খেরাজ মেয়াদী সাবেক 61 নং nang patta, 61 nang 60 nang dagor. So my lord, patta number 2, patta number is there, old is 61 and new is, then new, my lord, 25. And dag number, my lord, 63 and 67. 63, my lord. Yes. Thereafter, my lord, is exhibit, my lord, C also, kindly see, my lord. Exhibit see my seller, Sunil Kar and Balaram Kar. The two person, my lord, my seller. Kindly see, my lord, their schedule. Pentala Moja, Jyoti Kuti Gawa, Heraj Myadi, Firstly by Kosis. No. Patta number firstly by 67, my lord. My the last take, my lord, exhibit I. It is, my lord, it is the exhibit I, my lord, by which, my lord, the respondent passes the land, my schedule is also there, my lot of that majority to Kata My lord, these are the document of title, my lord. My lord, although, my lord, I am not supposed to, my lord, establish my title because, my lord, I am the defendant and my lord respondent here. It is the duty of the plaintiff to establish their title. Still, my lord, I have shown from the 4 documents, my lord, that these are the title deeds and these are, my lord, this there is a resemblance of patta, old patta and new patta. From their document also, here their document also, exhibit C, it is, my lord, in the facility, it is there. Yari patta number 40. New is something different, 830, but all is similar. Similarly, chart number 67. My lord, it is the resemblance is there. Same dag and patta, all are the same patta, my lord. Exhibit 7. Schedule. It is their document, my lord. Exhibit 7. So, my lord, my answer to the, my lord, this regarding dag and patta. My lord, now, my lord, I'm first of all, my lord, this defendant, my lord,
Yes.
my lord, yes, defendant, my lord, deny the title. My lord, kindly see, my lord, page 20 is my part of the WS, my lord. Page 20 is my WS.
It's the memo of appeal at
Yes, memo appeal, memo appeal.
Page number?
Page number 20. Paragraph, my lord, 4. That this defendant denied the title of Ananta Kumar, Arun Kumar, and Jagdish Kumar over the suit land. While, my lord, their reply is, my lord, original, my lord, title, they relying on, my lord, exhibit 1. My lord, kindly see exhibit 1. What is exhibit 1? So, I'm not
page number
coming up.
20 in the memo of appeal is not the written statement.
Memo appeal, WS is there, my lord.
Yes.
So, my lord, the defendant number one deny the title. Both in para 3 and para 4, they deny the title. To establish, my lord, their title, they exhibited exhibit 1. What is exhibit 1, my lord? Can you see, my lord? 1977 86 সনৰ বেলতলা মজাৰ জ্যোতিষপুথি গাঁৱৰ ডাক পিঠাৰ
Exhibit A is at page number.
মেলৰে their exhibit
No,
1.
sorry, exhibit 1 is the page number.
In exhibit number, my lord, just I handed over, my lord, the prior to my document, their documents are there. এটা নয় পুরোনো, হ্যাঁ এটাতে আছে, এটাতে আছে। হ্যাঁ এখানেতে আছে। Very fast document, my lord.
The orange
Okay,
flag.
okay. Got it.
So, my lord, this is the CITA of 1974-86. Dark number is there in the first column 67. Kali in the third column 16 giga 4 kata 5 letter. Patta number is also there. 25. Owner name is Dandiram Kumar, Saraswat Kumar. And in the next column, Raitar Nam, Pita Nam, Tikwana. Can you see, my lord, the next, in the case of Raitar Nam, name of 8 tenants are there. And what is the note below, my lord? Below the number 8 tenant, Dokhal 3 Basar. So, my lord, this land under occupation of the 8 tenants for 30 years. For 30 years, my lord. So, my lord, here from, my lord, 2, my lord, legal points come out, my lord. Number 1, CITA is not a document of title, my lord. On the basis of revenue record, whether it is CITA or it is mutation or, my lord, it is revenue paying receipt, no, my lord, title can be established. So, my humble submission from the exhibit 1, they cannot claim, my lord, title.
Yes.
My lord. Next, my lord, exhibit 2, this is the power of attorney. Executed on 16/10/1996. My learned friend already submitted, my lord. There is no mention of 4 boundary. There is no mention of 4 boundary of land measuring 3 figure, 4 kata and 7 letters. And this person, my lord, the attorney, my lord, Ranjit Dey, he sold 1 kata 5 lecha of land to appellant. By virtue of, my lord, exhibit 2, the power of attorney. So, my lord, my humble submission is this, my lord. Lower appellate court rightly hold that, my lord, out of 3 biga, 4 kata and 7 letter, it is very difficult to identify the land. And on this point, my lord, various judgment of Honorable Supreme Court in even of our High Court is there. I have enclosed in my written argument also, my lord. And who has given my lord this power of attorney? Number one, Pranam Kumar, number two, Arun Kumar, number three, Jagdish Kumar. None of that person, my lord, impleaded as defendant. They never turn out, my lord, in the trial court to adduce evidence. These three persons, my lord. Even, my lord, the attorney, Ranjit De, not impleaded. And he also did not turn upon, my lord, to adduce evidence in the trial court. And my lord, my learned friend pointing out this paragraph 3, that they sign, verify, execute any deed or deed, agreement, etc., etc. My humble submission, my lord, it is this Ranjit De is not the owner or title holder of the land. It is only, my lord, this Avantu Kumar, Arun Kumar, and Jagdish Kumar. They should come in the court to rectify this document. This is power of attorney. Include the four boundary. That was not done. That was not done. Only attorney rectifying the deed. So my humble submission, my lord, the attorney has no power, my lord, to include this land or that land out of 3 bigha 4 katha 7 lechas, my lord. So, my lord, if this exhibit 2, and my lord, kindly see rectification, their deed, their deed executed, first deed, which is they claim that deed of sale, it is executed on 23rd June of 1998. And my learned friend submitted that it was rectified after 6 years. It is not, my lord, it is rectified after 10 years. The next exhibit is exhibit 4 is the rectification deed. Rectified on, my lord, 18th day of July 2008. After 10 years. And our argument in the court below, my lord, when this appellant could not find his land, surreptitiously this included my land by changing the by inserting boundary where there was no boundary in the power of attorney exhibit 2. So, my lord, intentionally they rectify after 10 years to include my land. And that is why subsequent, my lord, all the deeds, my lord, rectified after 10 years. And all rectification on the same day, my. So, my lord, my submission is this, my lord, exhibit 2, the principle of the exhibit 2, that is Ananta Kumar, Arun Kumar, and Jagdish Kumar, they did not turn up to rectify the power of attorney. That is why, my lord, subsequently Ranjit De, rectification of Ranjit De is not valid rectification, and therefore, my lord, the identification of the land is impossible, and which was rightly held in, my lord, issue number 1 by appellate court. My submission regarding, my lord, is possession, my lord. In the amended plan, my lord, in paragraph, my lord, there is nothing stated when, at what time I dispossess them. Only, my lord, in column cause of action, this mention is there in the plain. My lord, regarding possession, my lord, there was, my lord, injunction petition filed by the appellant in the court below. Initially, my lord, an interim injunction was granted, but my lord, final order passed on 4/9/2009. My lord, very, my lord, important observation is there by the trial court, my lord. It is in the injunction petition, my lord. I have,
No, how that observation will help you?
because, my lord, I
Arguing
have
on the
not
point
read
of
that.
this substantial question of law.
That's right, my lord. Other questions.
Whether any question of substantial question of law was framed on that point.
My lord, their submission was there. I dispossessed. I
No, you
dispossessed. That is
confined
why.
your argument mainly on the substantial question of law.
That's right, my lord.
Then unless there is perversity, this court cannot go into the
Yes.
facts.
First, whether the learned first appellate court committed irregularity by ignoring the exhibit 2. Second, whether delay execution of rectification did correcting the boundary contained in the cell list would be itself raise a presumption against the validity of the title. Third, whether the finding recorded by the learned first appellate court holding that there was omission of mention that date of disposition contains to the pleading of the record, more particularly amended claim. Fourth is whether the plaintiff would have non-tweeted upon his alleged failure to prove the victim of the previous possession and dispossession of the title. Whether the learned court below was correct in discharging the distinctions of merely on the ground of alleged discrepancy in the said deed. Any other substantial question of law may be raised during the course of hearing. My lord, the trial court, while my lord dismissing the injunction petition, only observe on the basis of my lord their exhibit 1, that is the CETA, because apparently my lord 8 tenants are there, and under 6 of my lord Tenancy Act, my lord, the tenant has a right title and interest, my lord. That observation is there. And there is no whisper in the plain. No whisper in the plain what happened to that tenant, whether they relinquished or their tenancy, my lord. Given up to the landlord. I am reading my lord section 6. An occupancy tenant shall have permanent, heritable, and transferable right of use and occupancy in the land of his holding, subject to other provision of this act. So, my lord, subject to other provision, my lord, they may, they might have approached the deputy commissioner for their extinguishment. But, my lord, there is no mention about this, and it is their document. It is not my document, my lord. So, my lord, this trial court, while dismissing the injunction petition, they said that apparently they are not in the possession, because the possession of these 8 tenants are there for long 30 years, the relevant time. My lord, issue number 1, while discussed by trial court, my lord, issue number 1 start at page 58 of the memo, my lord. Kindly see, my lord, discussion. Page 65. My lord, in the middle, observation is like that. The defendant has failed to prove as to how the seller in the sale deed, that is exhibit A, B, and C, became the owner of the suit land. My lord, in a suit, my lord, it should be the plaintiff, my lord, and various judgments are there under evidence act section 101 and 102. It is the duty of the plaintiff, my lord. Thereafter also, my lord, below, my lord, about 7-8 line, my lord. Observation is like this: the mutation of a person in the record of right raises a presumption that he is the owner of the land. My lord, against the established law, my lord. This observation is against established law because, my lord, mutation in revenue record, not presumption of title, my lord. My lord, acquiring title, my lord, in page 63, learned trial court observed like this, my lord. 8-9 line from top, my lord. Page 63, my lord. Page 63. How the vendor of the plaintiff acquire ownership of the suit land has been proved by exhibit 2 and exhibit 3, exhibit 7, exhibit 8. The vendor of the Suman Das was the owner of the suit land. Here, my lord, very interesting thing also is there, my lord. Can you see, my lord? These two persons, my lord, two witnesses, my lord, they included page, my lord, defendant. Page, my lord, 12 of the memo. Defendant number 2 is Ravi Pal. Defendant number 4 is Suman Das Gupta. Two persons, my lord, despite of getting notice, did not turn up, my lord. They did not submit their written statement, my lord. But, my lord, the appellant brought them, both of them, to adduce evidence.
Suman Das Gupta and
My lord, in this respect, my lord, there, my lord, this evidence ought to have been thrown out, my lord. Because, my lord, one judgment is there from our High Court. He reported on, my lord, 2007. I have, my lord, included there. 2007, 1 GLR,
2000,
538.
2000,
2007, 1 GLR,
page number
page number 538. Onu Das versus Kozumi Das. I have written in my written, still I am reading one paragraph only. Paragraph number 8. My last judgment of my written argument. Last 2 pages. However, the court dismissed the evidence on a affidavit
paragraph number
8 minutes. Evidence filed on behalf of the defendant number 1 by the including order relying on which judicial authority reported in 1991 1 GLR 157 for the Acharji versus Hari Prasad Acharji and 2 AR 1989 Supreme Court 162 Modula India versus Kamaikya Singh. The ratio of those referred case law is where a party failed to file WS written statement within time submitted by the court may proceed with the further hearing of the suit, and the defaulting party may participate in the hearing but subsequently cannot be allowed to leave any evidence in respect of the defense on the ground of failure to file written statement. So, my lord, they both of their evidence will go. Evidence of Ravi Pal and evidence of my lord, this is Suman Das. So, my submission is that, my lord, if that exhibit 2, power of attorney will go, my lord, all subsequent deeds, my lord, claim to be the title deed will go, my lord. And, my lord, exhibit 2 is the that document, my lord, where there is no specification of boundary. And while deciding, my lord, this issue number 1 by appellate court, rightly discuss and observe, my lord, issue number 1 mainly, which is, my lord, regarding declaration of a right title in interest. I think I should not read again, my lord, issue number 1. My learned friend already read, my lord. If you lordship, my lord, think, my lord, I should read again the issue number 1.
No.
My lord. Then, my lord, I have written, submitted written argument, my lord, relying on 11 number of judgment, my lord.
Yes, Mr. Teka, any reply?
No, my lord, I'll just quickly respond, my lord. First of all, my lord, the argument that tenants are regarding the riots, my lord, I would say, my lord, with utmost respect, that's a self-defeating argument because they say they are in possession of the land, my lord. And to argue that the riots are in possession of the land would be contradictory to their own stand, my lord. Because the issue here is whether I should be in possession of that land or whether they are rightly in possession of the land. Now, for them to contend that the riots, it was actually nobody's case that neither of the parties are in possession. It's in fact the riots who are in possession. So that was nobody's case, my lord, first of all. Now, if your lordship has the exhibit bunch, my lord.
Which exhibit?
My lord, the DW exhibit, if your lordship has, my lord. No, my lord, the issue is not whether there are sale deeds or not. The question is whether the executants of that sale deed had title or not. So, my lord, first exhibit A is executed by Nondiram Kumar. Now, there is no document to show that Nondiram Kumar had the alienable right to execute the sale deed. That is the moot question, my lord. First, then second, my lord. So, if they cannot establish that Nondiram Kumar had title, no matter how many sale deeds he executes, my lord, it will not sort of vest title on the purchaser. Second is, my lord, your lordship has seen the description in Exhibit A, the third page, is 60 Echostinong Pattar, Techostinong Dag. Echostinong Dagor, Techostinong Dag. Now, there is no document to show what was Patta number 61, who were the recorded Pattadars, and whether 61 Patta number became 25. There is absolutely no document. Now, my lord will kindly have their own document number H, exhibit H. On one hand, they say Patta number 61 became Patta number 25, whereas in exhibit H, that's the There it says, Puroni, has your lordship found it, Patna number in that the sixth column. Sixth column, right? 61 Puroni, 24 nong notun. The Sud Patta is 25, my lord. Now, lastly, if your lordship sees from their documents exhibit N, this is their own document.
Exhibit?
N for Nagaland. Now, this is the Kacha Patta exhibited by them, my lord. Now, if your lordship sees, out of those, the entire old Kacha Patta is shown. That is number 25, which is a concerned suit Patta. Here, none of their vendors' names are there, but in their own document at serial number 10 and 11, serial number 10 and 11, Arun Chandra and Jagadish Pita Roheswar. So, the original owner, who were the original owners according to me, their names are figuring in their own Patta, in their own Kacha Patta. And whereas their vendors, Nandi Rai Kumar and all of them, my lord, none of their names are mutated. So it is a paper transaction at best. Now, plaintiff's exhibits, on the other hand, first of all, to show the title, there is exhibit 1, which is the Chitta, where the name of Dondiram and Roheswar are figuring. Then there is exhibit 5, which is the Kacha Patta in the name of Robipal, who is also an intermediary purchaser. I have already shown the deed. Then exhibit 14, exhibit 13 and 14. 13, first of all. This is the mutation certificate in the name of Abhishek Shah, the plaintiff.
Exhibit number 11.
13.
Yes.
This is again in the name of the plaintiff Abhishek Shah. The following exhibit, which is the Joma Bondi. There also, Robipal's name is there, who was the intermediary purchaser. His name has been struck off and the plaintiff's name has been entered at serial number 2. Robipal, then number 2 is Abhishek Shah, that is the plaintiff. And lastly, to top it all, exhibit 15, if your lordship sees. This is the Patta in the name of the plaintiff. Now, other documents aside, this itself is a document of titlement. Abhishek Shah, and on the flip side of it, your lordship find, now it has been allotted Patta number 29. The area is 3.21 hours, which is 1 quota 5 letter. So they have sale deeds, my lord. First of all, those sale deeds have been executed by persons who are not recorded pattadars, nor are there any documents to show that they were title holders, my lord. Whereas the plaintiff has a clear chain, my lord. And boundaries, my lord, there none of the sale deeds have boundaries. They are trying to find fault with that the original power of attorney did not have a boundary. Whereas, except the sale deed in favor of the defendant, all other sale deeds relied by them, neither of them have boundaries. And lastly, that order of injunction eventually having merged with the final order, final decree, that injunction order today, in my respectful understanding, doesn't hold any value.
One thing, my lord. My humble submission that, my lord, a appellant is plaintiff, my lord, absolutely failed to establish their source of title. What is their source of title, my lord? That is exhibit 1. Exhibit 1. What is exhibit 1, my lord? Exhibit 1 is Sita.
And my lord, I am denying my lord this title of my lord, this Ananta Kumar, Arun Kumar and Jagdish Kumar. Where is that document, my lord? That they, my lord, the appellant to establish, yes, they are the title holder. No document, my lord. Only subsequent document. If, my lord, there is no source of title, my lord, by document number 1, there cannot be subsequent title. And this title, my lord, honorable court cannot rely because there is no source of title. I mean, my WS, I categorically deny the title of my lord, this is 3%. Even my lord, in my document, suppose my lord, I have not exhibited any document. My lord, I am defendant. It is the plaintiff, my lord, it is the duty of the plaintiff to establish their title first, then thereafter recovery of position. So my lord, they desperately fail to, my lord, establish their title. There is no any document to show their title, my lord, prior to, my lord, this power of attorney.
My lord, the other case, my lord, is also is the same, my lord. There is just
There is the same point of view, my lord, law, my lord, involved. And only, my lord, same power of attorney, exhibit 1, 2, all are same. Only, my
So
lord,
there are two RSA.
that
yes,
queries. I can indicate, my lord, to the court master what the difference is. My lord, Ranjit Kumar De sold it to Ravi Pal in the first case, my lord. He also sold it to Ojit Chandra Das on the same day. And from Ojit Chandra Das, the second appellant in the second appeal had purchased it.
this is the difference.
So from Dondiram, it came to Ranjit. Ranjit sold it to Ravi Pal on one hand and Ojit Kumar Das on the other. From Ravi Pal again, Subhash, Suman.
Both are arising out of the same judgment.
Same, my lord.
No, different suit.
Difference,
Difference.
my lord, but the same point, my lord, procedure is the same, and my lord, appellant to appellant, defendant is the same. Two appellant, my lord, same question of law involvement.
Okay. Art Mr. P.T. Dekel, learned for the appellant, so on for the response.
Objection.
Lordship, will you like to defer the matter for today? It will take time.
How much time will you take?
It shall take almost 1 year, 1 hour,
1 hour.
1 hour.
So let us start.
This concurrent findings case appeal. It was formulated, two substantial question of law was formulated by order
Mainly on
dated
jurisdiction.
Lordship.
Mainly on jurisdiction.
Lordship, law point also is also there.
In fact, both the questions of law are not substantial.
Lordship, let us see.
Not substantial, my lord.
Lordship, let us see.
The
If,
concurrent finding is different.
no, it is not that there are certain
Okay. Yes, sir.
by the order dated 28/2014. Whether the suit of the plaintiff for eviction of defendants is barred under section 54, subsection 2 of the Assam Temporary Settled Areas Tenancy Act 1971.
So let us see what is the section.
Second one is that
Assam Temporary Settled Area Tenancy Act. Settled.
no tenant shall be ejected from his holding except in execution of a ejectment decree passed by the competent civil court, and the relevant provisions of civil procedure code shall apply to such proceedings. 2.1. 2. No suit for ejectment of tenant on the grounds of mentioned in the section 51, subsection 1, subsection 2A and B shall be entertained unless the landlord has first served a notice on the tenant requiring him to remedy or to pay compensation for the misuse or the breach of complaint, and the tenant has failed to comply within the 1 month of the receipt of the notice. 3. If it appears that court that trying the ejectment suit, the complainant of complaint of misuse or breach of true but remediable, then it may direct the tenant to remedy the misuse or breach or to pay the reasonable compensation fixed by it within a specified date, and if the tenant fails to comply with the directions, shall pass a decree unless there are other reasons for not passing such decree. 4. No suit for ejectment on the ground of mention under section 51 to C shall be entertained unless first a decree for rent has been obtained. 5. No suit for ejectment on the ground mentioned under 51 to subsection D shall be entertained unless a 3 months notice along ending with the expiration of lease has been served upon the tenant. Now the ground of ejectment is shown in that section under section 51. This ground of ejectment is common for both the occupancy tenant as well as the non-occupancy tenant.
51.
51.
Yes.
An occupancy tenant shall not be ejected by his landlord from his holding except on the execution of decree for ejectment passed on the ground that he has misused the land comprised of his holding in a manner which renders it unfit for purpose of tenancy. Any tenant not being a occupancy tenant shall not be ejected from the land in his tenancy except by execution of a decree for ejectment passed by any one or more of the following grounds, namely that he has used the land comprised of his holding in a manner which renders it unfit for purpose of the tenancy, that he has broken the condition of tenancy within the provision of this act and on the breach of which he is under terms of contract between them and his landlord is liable to be ejected, that he has failed to pay the arrears of rent. This is the case. Failed to pay the arrears of rent. That the land is bona fide required by the landlord for his personal cultivation. No notice for ejectment on this ground shall be entertained before expiry of 12 months and after expiry of 15 months from the date of creation of tenancy, provided that if the tenant has no land or has land less than 10 bighas, then he shall not be ejected on this ground unless he has been left with so much areas as will make the total of his holding equal to 10 bighas. Provided further, if the landlord does not cultivate the land personally within 1 year of the date of ejectment, the tenant then shall be restored to his possessions. Lordship, their case was that we are tenant. We took the tenancy in the year 2001. 2001 we paid, 2002 we paid, 2003 we paid. In the year 2004, we refused to pay the rent. Rent in the form of cash, not in cash, adi, in kind. Either it is a kind or cash. Now here is the case, we took the plea that yes, we are protected under the Tenancy Act of 1971. Therefore, we cannot be ejected because in that case, the second substantial question comes into effect. Whether the suit for eviction against the landlord defendant, tenant defendant could be filed on the ground of default of payment of rent without filing a suit under section 34 of the Assam Tenancy Act 1971. That means in the case of that, if you have failed to pay that rent, in that case, there should have been a first rent suit. Because there was not the ground that we did not use that holding, unfit for holding. We broke the condition of tenancy that we failed to pay that. This is the only count that failed to pay the rent. If you have failed to pay the rent, there should have been a rent suit under section 34. Now let us come to the under section 34. When the rent, when the rent is due for payment, cash rent shall become due for payment of fortnight earlier than that of corresponding land revenue, which is payable by his landlord, becomes due for payment, or where the landlord is liable to pay the revenues, shall become payable. Crop rent shall be paid from the delivery within 60 days from the date of harvesting the crops. Now, that was the case that crops rent 60 days. 60 days, then agriculture year starts always in the month of Bahag, ends with Soit. So 3 years, when they says that we fail to pay the rent, whether we are covered, we will be declared as an occupancy tenant or non-occupancy tenant. Because their own admission says that, their own plaint says that we paid the rent, we took the tenancy in the year 2001. They have not specified when we took, which month, they have not specified. We paid the rent for the month of 2001, 2002, 2003. It is a clear case of 3 years. Therefore, we are protected. We are a occupancy tenant in the, not that they occupancy tenant, but both the courts, trial courts as well as first appellate court held it that we are non-occupancy tenant. Even if it is not admitted that even if it is, we are not occupancy tenant, only non-occupancy tenant, we are still protected. How? Why? Because there has to be a suit first for rent suit.
For recovery of the
Rent.
under
Section 34, that provision, section 36 comes, rent suit. What is rent suit? No arrears of rent shall be realizable otherwise by than a rent suit other than the competent civil court filed in the competent civil court. The procedure for such rent suit shall be according to the provisions of civil procedure code and shall, in addition to the matters under section 1, 2, 3, 4, 5, 6 and sub rules so and so, specify the areas of land to which the suit relates, which fields are numbered in the village papers, and the number of any areas of field, suits and areas, amount of the yearly rent which is payable. Where the land to which suit relates does not form any of the fields numbered village papers, the plain shall contain a sufficient description of the land and its boundaries. That was not done. Secondly, if we are a tenant, we are, as per section 54, we are supposed to issue notice. Exhibit says that no notice was served upon us. Under section 54.
So, Mr. Bhagavate, tell me, is there any requirement of law for filing a suit under 34 first?
Lordship. Why? Because it is their case is that we did not pay the rent, either cash or kind. In the year 2004. 2001 we paid, 2002 we paid, 2003 we paid. In the year 2005, 2004 we did not pay.
Not it would be better if opponent first go through the plaint and written statement. What was their stand in the written statement and what was our stand?
Lordship, yes,
that will clarify. Then the law will come.
Lordship, that is what is. Assuming that our written statement, we took the plea, 71 plea, Tenancy Act plea. Otherwise, simply denied. And as a defendant, I can take both the plea, inconsistent plea also, contradictory plea.
Yes, you may.
I may take. I took the plea that yes, I said that I am protected by Tenancy Act of 1971. One. But in title, I decided to deny their title. That is the contradictions. That is why let us not go to our written statements. Let us go to our first their claim. If they are able to prove that we are tenant, then if the tenant, all right, that is there.
Okay.
So Lordship, let the matter be adjourned for today. I'll also come more prepared because he has raised the question. I'll come with that also, written statements. Let it come in another day.
Heard Mr. Bhagavati, learned Buddha appellant. And Mr. Soruri Buddha respondent. Heard in part, please the matter. As stated.
Any day.
So after vacation time.
Yes.
Lordship.
After.
Lordship.
No, Mr. Bhagavati, you did not answer my question. Whether there is a statutory requirement
Yes,
that
Lordship.
before filing the suit
Section-
under this 54(2), you have to file a suit under this 34.
34.
Yeah.
That is statutory requirement is there.
That's it.
That is there. That rent suit has to be filed. In the case of rent suit, we fail to pay that. Then we can pay back also the amount. Then we become automatically again tenant. The moment we pay back the rent, we become again, we will be, our tenancy will be restored. It is a stringent act. Tenants has a upper hand.
They have claimed their own title over.
All right, I have told contradiction. I can take contradictory view
Then this question will come my lord, regarding tenancy.
because both the courts gave the delivered the judgment on the basis of the plaint only. That occupancy tenant, non-occupancy tenant. That is the moot question.
Judgment will be delivered on the pleadings of the both sides. No.
All right, but it was not our thing. All right, that let us not continue.
Well,
Please, Your Lordship, I'm appearing on behalf of Mr. D.K. Das for all
Sir?
the Mr. D.K. Das.
Dictator.
Yeah, for all the respondent. Lordship, my senior mother has recently passed away. So he's in bereavement, and so Lordship kindly adjourn the matter for 2 weeks of time.
Then,
My lord, since
yeah.
there is a difficulty, genuine difficulty, my lord, I
Yes.
must
Your good
consider.
name, please.
W. Akhtar, Lord.
W.
Akhtar.
Akhtar, learned counsel. Appearing on behalf of Mr. D.K. Das submits that Mr. D.K. Das, the learned leading counsel is on bereavement and tries for listing the matter after 2 weeks. Having not been objected by Mr. Sen, learned counsel for the petitioner, the matter stands adjourned to be listed on 24th of April.
Obliged, my lord.
I think
Where is the appellant?
There's a money decree in my favor, Your Lordship.
Your paper.
And then there's not present.
Then appears for the appellant on call. How about Mr. Mukherjee, learned counsel for the respondent present? List the matter 2015 matter. List the matter immediately after reopening of the we will fix it. 29th April. In the event of subsequent no shortage. In the event of subsequent non-appearance, non-representation of the appellant, appropriate orders will follow.
15.
This is against for
Patrimonial appeal by the husband, lordship. and-
husband.
Yes, and also
Is it dictated or rejected?
it was rejected.
Reject.
Husband preferred the, husband filed the title suit for the decree of divorce on the ground of mental cruelty wherein it was rejected by the trial court.
On the ground of
Mental cruelty. Cruelty.
cruelty. So how much time will you take?
Depends.
Will you be able to complete today?
We can make an endeavor, or lordship, if your lordship suggests some other day, it's okay for me.
Mr.
Because-
Borua, are you prepared?
Yes, Manoj, I just want to place three judgment, mental cruelty, Samar Ghosh judgment, and I want to submit that this facts and circumstances, this touchstone by Samar Ghosh case is not fit. So that is my simple submission. Otherwise, what my learned friend has taken time, I will take 10 minutes or 15.
Okay, we'll list it on Tuesday, coming Tuesday. At the top of the list, I think.
Lordship, Tuesday will be a little difficult for me. Can it be on Thursday then?
Thursday.
Thursday?
Okay.
That is 27th.
Yes. As agreed by learned advocate to put the part that is the matter on Thursday. That's the top of the list, I think.
Obliged.
Last time LCR was called for, but then
Whether LCR will receive. Not. Okay. Heard Mr. Mahmood learned counsel for the petitioner and Mr.
M. Rana.
M.
M. Rana.
M. Rana learned counsel for the respondent. Office note dated 18/3/2025 indicates that to the record of learned trial court was requisition. The same has not yet been received. Accordingly, it is provided that recital reminder the learned trial court for transmitting the record without delay and list the matter on 29th of April.
17.
Order of this honorable. Today they are absent. Several times they are taking.
Now they are absent.
They are enjoying the stay now. That's why they are not appearing and taking time.
None appears for the appellant on call. However, Ms. Kananko present. S. Kananko when present for the response. Recital is the matter on after vacation then, madam.
A fixed date, lordship.
In the event of subsequent non-representation of the appellant, the court will not only consider vacation of the interim order, but also consider extension of the appeal for non-prosecution.